deferred. I was mistaken. Pardon? I'm rotating.
Yeah, no, I will, I'll break that. I think. Good morning and welcome. It is Friday, Gay Friday, November 21st, 2025, on day 2 of evidentiary hearings on docket 250811. I am Commissioner Holly Cheeseman. I am joined today by Vice Chair David Arconti, Commissioner Michael Karen, Commissioner Jan Beecher. I have been elected by the panel to serve as presiding officer of this proceedings. So at the moment, are there any public comments? Seeing none, are there any administrative matters before us? And I am aware that the question of the conflict between the late filed hearing first day and the Hazardville Water Authority is still outstanding. We will resolve that as soon as possible and notify all parties. Are there any other administrative matters?
There are, Commissioner. Good morning. For the record, David Bogan, on behalf of Charter Communications. 2 issues. One, we do have an additional witness today. I had indicated Wednesday that Ms. Kim would be here, so we will need to swear her in. But before we do that, I do have one procedural issue I'd like to raise. Going back over my notes and reflecting on the questions that were asked, particularly at the end by the Office of Consumer Counsel, as I indicated Wednesday, the lengthy prefatory narrative is inappropriate. If we could simply limit it to questions, it would be appreciated. I think that's proper process. Second, the companies have no expectation that the OCC will be limited to questions only on their interrogatories that they ask. They can certainly ask other questions. The problem is that they had extensive discovery. The Consumer Counsel issued over 300 interrogatories. And some of the questions that are now being asked look more like those that should have been asked by way of interrogatories. I mean, to ask when a bill is sent and whether a stamp is put on it, that's inappropriate, number one. Number two, these witnesses are not going to be able to answer that. Mr. Falk testified that he oversaw the production of the responses to the discovery. But to ask these witnesses those sorts of questions is neither efficient nor productive. This is a multi-billion-dollar transaction. To ask when a bill is being considered delinquent is inappropriate. It's not productive. It's not probative. And if the OCC wanted to ask these questions, it could have done it in interrogatory. It chose not to do that. It seems that the OCC wants to have a broader policy discussion. The problem is, and Commissioner Karen has certainly lived this for the last few years, 18 years ago, the legislature chose to change the rules. And it said, listen, legacy cable companies, you may have another option here. We're going to create a new landscape. We're going to call something a CVFA, a Certificate of Video Franchising Authority. I think AT&T or whatever its iteration was at that time was the first to do it. And it said, oh, once that happens, because they were going to be freed of a lot of the legacy requirements, the traditional cable companies would have the right to be known as CCFAs, Certificate of cable franchising authorities. Once that nomenclature was adopted, most of the legacy requirements and statutes went away. And so to ask questions now that seem to suggest that some of those may still apply, it would be the first time in 18 years that it's been raised. If OCC thought there were compliance issues, it could have raised those issues before, but it didn't. This is not a generic proceeding to look at compliance. This is a proceeding that should be focused on managerial, financial, and technical qualifications and whether the transaction is in the public interest. Whether or not a stamp or something was sent first-class mail is not going to managerial, technical, or financial qualifications. And if it is deemed that it is, we're jumping quarters to chase pennies. So I'd simply ask that the questions be focused on the criteria that should be before this commission. I don't want to have to jump up every 5 seconds objecting to a question that could have been asked by interrogatories or goes to legacy requirements that no longer apply. Thank you.
Attorney Bogan, is this an objection?
I guess it's a prefatory objection to what I assume are going to be questions. And it's much like in the vein of the one I issued the other day.
Well, if I may, let me say this. I would urge, and I will allow Office of Consumer Counsel, when this is lodged, an objection to respond. As far as possible, if your answers would your questions would have been more properly placed in interrogatories, can you bear that in mind? And if the answers were supplied previously in interrogatories, will you bear that in mind? On the other hand, if the questions are directly related to the issue at hand in terms of public interest and change of control, and there are substantive issues that this witness panel can answer, I will not preclude the ability of OCC to pose those questions. Is that satisfactory, Attorney Bogan?
That's fair.
OCC?
Yes.
Claire Coleman, yes.
Good morning.
Good morning.
Good morning, Chair, and to the rest of the commission. Claire Coleman, Consumer Counsel. I just wanted to stand up in defense of my team here. It appears to me, hearing Attorney Bogan's comments, that the companies are attempting to have it both ways. They don't want us to they've objected to asking questions around legal and jurisdictional issues, which I think is a fair objection, and we intend to stick to the facts, yet Attorney Bogan seeking to limit the scope of the discovery around his own interpretation of the law and the appropriate scope of the authority's jurisdiction. So the team will be asking questions focused on consumer protections today. It's intended to develop an understanding of current practices as well as future commitments that the company is willing to take. I think this is very appropriate content. It's not duplicative of interrogatories. There is follow-up to interrogatories, which is certainly what these hearings are designed for, right? For example, understanding the timing of a bill is certainly a really critical component to consumer protections that we're concerned about. Our customers getting the right amount of notice before being deemed delinquent. So I would object to that being an inappropriate question. And while we certainly will seek to move the hearing along as expeditiously as possible, I'd just like them to have the opportunity to cover the ground they intend to today.
Thank you.
Thank you.
I don't believe I referred to it as inappropriate questions, but I will, what I will say is if there are very granular issues that are outside the purview of the witnesses today, I would think the more appropriate avenue to address them would be in late filed exhibits, and they would be at that point. If the information can be made available, that would be the appropriate avenue. Is that satisfactory to
Absolutely.
our parties?
I guess it will have to be.
All right. Any other administrative matters before I open another can of worms?
Just this, Your Honor, and that is at the end of the proceeding, I think it's appropriate that we talk about not only the LFE hearing schedule, but also the briefing schedule, which probably we're going to request be adjusted.
All right. Well, we will address that at the end of the hearing if that would be suitable for everyone. If there are any additional administrative matters that we need to do before we adjourn. And Attorney Bestor.
Thank you. Good morning. So we have an administrative matter to bring to the authority's attention related to a response that was submitted to an interrogatory. And so we actually have an update to a response that is new as of yesterday. It would involve our witness giving some additional statements. So if you would like to take that now, we can do that, or we could do it as part of our read-ins, that we also have a few read-ins in a moment. So I will defer to you on timing.
I think it would make sense if you could include those in the read-ins,
Okay.
please.
Yep, thank you.
All right, moving on. We don't have any new appearances today. All right, if you could introduce your new witness, Attorney Bogan?
Ms. Kim, could you please state your name, affiliation with the company, and your business address?
Thank you. My name is Greta Kim. I am a Group Vice President of Customer Service for Charter Communications, and my business address is 400 Washington Boulevard, Stamford, Connecticut, 06902.
Thank you. We can swear in.
All right, will you raise your right hand, please, Ms. Kim? Do you solemnly swear or affirm that the testimony you are going to give today is the truth, the whole truth, and nothing but the truth, so help you God, or upon pain or penalty of perjury?
Yes.
Thank you. Will you ask your witness to adopt testimony, please, Attorney Bogan?
We'll certainly do so. Ms. Kim, did you assist in the preparation of the application that's the subject of this proceeding?
Yes.
Do you have any changes, additions, corrections, modifications to make to any of the contributions to the application?
No.
The information for which you are responsible, true and accurate to the best of your knowledge and belief?
Yes.
Did you adopt that as your testimony in this proceeding?
Yes.
Did you also assist in the preparation of certain interrogatory responses submitted on behalf of Charter in this proceeding?
Yes.
And do you have any changes, corrections, modifications to any of those responses?
Yes, I do.
Could you state what that is?
Upon further review of one of our responses to OCC 65, we discovered a calculation error to part of the data provided as part of average internal call transfers, where there are updates to the data provided for the years 2023 and 2024. We will be filing update, and these changes are favorable to Charter and reflect our improving internal transfer rates.
Thank you. Excuse me. And with that correction, is the information contained in the interrogatory responses true and accurate to the best of your knowledge and belief?
Yes.
And do you adopt those as your testimony in this proceeding?
Yes.
Thank you. Ms. Kim is also available for cross-examination now.
Thank you. So with that, are we appropriate to proceed to cross-examination? Office of Consumer Counsel, you have the floor.
Thank you.
Excuse me, sorry, I don't mean to interrupt. I think it makes sense to do the
Would you like to do the read-ins first?
read-ins first, because it might,
All right,
Objection.
if you have no objection, I stand corrected. Thank you. If you would like to proceed with the read-ins.
Mr. Stamp, would you like to do our read-ins now?
Yes.
Can you please proceed with our read-ins?
Happy to. I believe we have 3 plus the matter that Mr. Bestor discussed earlier. So as to read-in 1, our understanding of the question was, do the syndication fees noted in Bureau 5 go up if the number of subscribers go up, and is the increase linear? And the response to that is our syndication fee is both fixed and variable. Therefore, it's only a partial linear relationship between the number of subscribers and the syndication fees. So in layman's terms, basically we pay an annual licensing fee, but then there's a fixed subscriber fee on top of that. So it's not purely one or the other. As to read-in B, the question was, are there any opt-out rights for Cox consumers in addition to what's required under Connecticut's data privacy law? And that answer is there are no additional opt-out rights beyond what is required under law, but Cox fully complies with the requirements of Connecticut law. And as to read-in C, is Cox Connecticut Telecom a certified telecommunications provider? And yes, Connecticut Telecom LLC has a certificate of public convenience and necessity granted by PURA in docket 970326 and is therefore a certified competitive telecommunications provider in Connecticut. And then turning to AG 13, we would like to put additional new information to update Cox's response to AG 13. CEI has identified a reportable incident under Connecticut law and submitted yesterday a report of that incident to the Connecticut Attorney General. At a high level, the cybersecurity incident involved Oracle's e-business suite, which is a third-party platform used by many businesses, including Cox Enterprises. We are aware that certain CEI data was involved in this incident. As far as I am aware, there were only a very small number of Connecticut residents impacted by this. The incident primarily involved CEI vendor information, including independent contractors, and to the best of my knowledge, did not implicate CCI, Cox Communications, Inc., customer data. I'm available to try to answer questions regarding the incident, but there's not much more I can say at this time.
Are we good to proceed now?
Yes, Commissioner.
Thank you. Thank you for that information. Office of Consumer Counsel.
Thank you, Commissioner. My name is Rihanna Ash. I'm a telecom policy advisor with Office of Consumer Counsel.
Excuse me, I'm sorry to interrupt. We have read-in as well.
If we would like to get all the read-ins out of the way at once,
it's up to you. I don't care. It's related to the same issues.
there are people here who are more experienced at doing this than I am, but so I will defer to them. If it would make sense, I will be guided by our esteemed company.
Accepted.
Of course.
It would probably be more efficient to do it now. I was not aware Mr. Falk was prepared to do it now, but if he is, we can proceed.
All right. If you would like to proceed, then Mr. Falk.
Perhaps I'm the only one who has less experience of it than you, so I'll follow our esteemed colleague as well. Apologize. So the question, we had the same question, does the charter today provide opt-out rights that go above and beyond what is required under Connecticut law? I think the answer is generally yes, as it relates to certain opt-out rights for marketing and establishing interests of consumers. We offer a broad range of privacy choices to consumers, not just in Connecticut, but nationally. Consumer choices is important part of giving consumers control and how they process personal data. Some consumer choice options are available to all customers, irrespective of their state of residency or whether they subscribe to charter services. Some choices are available to subscribers of a particular service. Others are available to consumers of a particular state like Connecticut. We maintain a webpage that directs people to their privacy rights that are available to consumers and non-consumers alike, or non-customers alike, customers and non-customers, which contain all of our spectrum privacy policies and other information regarding consumer privacy. It links to the privacy preference page, which consumers can exercise their choice about how they receive marketing communications, or if they receive them at all, and how Spectrum uses customers' personal information. All consumers can manage their marketing communication preferences by opting out of a variety of marketing communication methods. For example, Spectrum's do not call, do not email, do not mail, or do not knock lists. Subscribers of Spectrum service can also exercise a variety of consumer choices that are specific to their services. For example, if an individual subscriber to Spectrum's home phone or our mobile service wants to, they can opt out of the use of certain information known as CPNI, customer proprietary network information. Spectrum subscribers can also opt out of interest-based advertising delivered online through cable TV services and on our various consumer applications. Customers and non-customers in Connecticut can also exercise consumer choice, opt out of the processing of personal data for targeted advertising, opt out of the sale of personal data, opt out of the use of personal data for profiling purposes, and opt in for the processing of sensitive data. I think we were also asked to charters opt-out options for consumers differ from Cox's. Although the companies, again, are in the early stages of integration planning, and our business-to-business discussions remain ongoing. Our initial evaluation is that the two companies offer the same or very similar consumer choice options to their respective customers, and we'll continue to evaluate if there are any differences in the application of those consumer choices in the future. But at this stage, we believe that the two companies are very similarly aligned in their consumer choice approaches in Connecticut. Thank you.
And that was the extent of your read-ins, correct, Mr. Falk?
That's correct,
That
yes.
is correct. We had just read in B.
All right, thank you. All right, having cleared that hurdle, we will return to Office of Consumer Counsel for cross-examination. Ms. Ash.
Thank you, Commissioner. Charter, this first question is for you. Do personnel who enter consumers' homes receive a background check as part of their onboarding?
I believe the answer is yes. Brenda?
Yes,
Yeah,
to add, as part of the onboarding process for new employees, a background check is conducted.
correct.
Thank you. And can you tell me, do contractors who enter consumers' residences receive the same screening?
No.
We ask our contractors to abide by certain terms. I cannot speak to the specifics, but I do believe that they follow a consistent policy.
Take a read-in or an LFE on that.
Yeah, I believe they do as well, but I don't know for sure, and I would want to mislead you, so we're happy to get that information for you.
Thank you.
A late filed exhibit then on the question of contractors' background checks, correct?
And of course, you're talking about contractors applicable to work in Connecticut, I assume.
Yes.
Yeah.
Yes, specifically that enter consumers' homes.
Yep.
And this is for charter.
Yes.
Thank you.
We just one point I would make, and we'll still get the answer to the question for you. But we use very few contractors to do work in consumers' homes. It doesn't mean that we never do. But the bulk of our contracting activity is associated with network construction. We don't use outside contractors for network maintenance. We don't use them for trouble calls in the consumer's home, and we use them sparingly related to installations. But the question is still applicable in those instances. I just wanted to give you a fuller picture of the fact that we are not using contractors frequently as it relates to work inside a customer's home.
You can include that in the LFE, that information.
That's, yeah.
Sorry, and just to confirm, this is late filed exhibit 6, 5, 7? Okay.
That's already included in one of our other interrogatory responses in which we were asked about the use of outside contractors. So I was paraphrasing a prior response that's already been provided. Not the question about background checks of the contractors, but in terms of the use of contractors on behalf of the company as it relates to our field service activities.
Thank you. Cox, the same question to you. The first one was, do personnel who enter consumers' homes receive a background check as part of their onboarding?
Yes, they do.
Thank you. And do contractors who enter consumers' residences receive the same screening?
I think my answer is similar to Charter's. I'm not sure if it's exactly the same and happy to participate in the LFE to get you that information.
So that will be late filed Exhibit 8.
Thank you.
Same request of Cox, background checks for outside contractors, correct?
Exactly. Thank you. Back to Charter. Do employees and contractors receive specific training about entering consumers' homes? And if so, what kind of training do they receive?
They absolutely receive training. I don't have with me their training manuals or and I can't tell you exactly what that contains.
Would you be willing to provide them into the record?
I'm going to object to the question. This is precisely the type of granular questioning that could have been asked by way of an interrogatory.
We'll have a brief recess. All right, I'm going to overrule that objection. I believe if at all possible, this information should be supplied. I think it is pertinent to protecting consumers in their homes. So I presume you're going to ask that of both Cox and Charter?
Yes.
So details as possible of training that employees and outside contractors are given as regards interaction with customers in their homes,
Yes.
as late filed exhibits 9 and 10.
Can you repeat specifically what it was again? Sorry.
Details of training supplied to employees and contractors as to appropriate behavior inside customers' homes. Is that
Yes.
Yes.
a good summation?
Better than I said. Yes.
So if possible, I believe it'd be easier to provide a narrative description of these trainings rather than the specific manual.
I don't think you need an actual manual. It's just a general
General
overview of how these contractors and or employees should behave, their expectations of behaviors when they're in customers' homes.
Yes.
Thank you.
And as further context, these questions speak to what the companies are currently doing. And then I'll also be asking about what the plans are post-merger so that we can ensure that the best practices from both companies.
And I am going to preempt that. I think it's been made clear that the plans are still in the very early stages. I don't think the companies are in a position to supply what they're going to be doing post-merger. If they wish to include in their answers that there will be collaboration on continuing best practices, I think that should be sufficient for the purposes of this hearing.
I'll proceed accordingly. Thank you.
Thank you.
Cox, this question is for you. Can you tell us what specific training your employees and contractors receive before going into a consumer's home?
It's my understanding that that had already been assigned to us as a late filed exhibit.
That was the question you posed.
For both? Oh,
I said, I assumed you would apply it to both, so.
appreciate that. Thank
Yeah.
you. Okay. I'm going to move on to some billing and package questions from both companies. So to make sure that I understand correctly what was discussed yesterday, can both companies confirm, will current Cox cable tiers and packages remain available to existing consumers post-transaction in Cox territories?
No, that's not our plan. Our plan is to allow existing customers to keep their services if they choose. Other services that Cox provides today, we don't expect to continue to provide post-transaction. And I think, again, that will benefit consumers, not harm them. As we demonstrated yesterday, those packages are generally lower priced and better valued. Doesn't necessarily mean in every instance, but in most instances, those packages and prices are offered at a better cost to customers than the existing plans and packages.
Okay. Would it be correct to use the colloquial term grandfathering for those existing Cox customers who have the choice of keeping their packages?
I think that would be appropriate, yeah.
Okay, thank you.
Meaning that we don't expect to continue to sell those packages to new customers going forward.
Okay. And will that policy be applicable to cable-only packages or also bundles?
Bundles as well.
Okay. And I believe you likened this to the practice following the Time Warner cable transaction, wherein Time Warner customers were able to keep their grandfathered packages. Is that correct?
Correct.
And can you tell me, do any former Time Warner cable territory customers still have their grandfathered packages?
As of very recently, I believe that they have, yes. I don't, yeah, yes.
Oh,
Those
so,
packages have been maintained for for the last 9 years. And so I think there's many fewer that have them today than had them at the time of the transaction. So, yeah.
I'm just going to
I
jump
mean,
in. Mr.
perhaps
Buck.
Greta can answer whether there are any that remain. I don't.
May I just interject?
Yeah.
Just one quick question with that. Is that grandfathering that I'll take your response as you said it may still exist, or it does still exist. Is that as a result of a voluntary approach by charter, or was that mandated, for instance, by the New York Public Service Commission?
There were elements that included both. So the New York Public Service Commission didn't mandate that we maintain existing packages in Connecticut or in California. They also didn't mandate that we maintain them forever. I think there was a short period of time in which they asked that we agree to continue them, and they were continued for a lot longer period. There were also certain other elements of that were different than the question that's being asked. I don't remember all of the qualifying conditions in the language of the order, but there was an element of that contained in the New York order.
Thank you.
Thank you. And can you confirm whether any of those grandfathered packages have been discontinued?
Yes, certainly, many of them have at this stage, almost 10 years later. So yes.
Might
If-
you,
Sorry, if I may add, we are constantly enhancing the value of our packages. So our newer, more updated packages, which are available to existing customers as well as new customers, do have, in many cases, more speed and more value, such as access to the seamless entertainment apps that now come with our TV services. So, so these new packages are more attractive to customers as they look to make any changes to their previously grandfathered packages.
thank you. I'd like to ascertain how long after the merger, the first package was discontinued that was stated to be grandfathered.
I wouldn't have that information, nor do I think it's relevant.
We'll take a read-in or a late filed exhibit on that. We're asking it because we do think it's relevant to the future of the Cox, the current Cox customers.
Well,
I would say what is more relevant would be their plans in terms of grandfathering going forward, not what happened in the past.
Unfortunately, Your Honor, they are unable to tell us their plans going forward, as you indicated earlier.
Well, no, we did tell you that our plans are to allow existing customers to maintain their current plans if they choose to do so. What we can't tell you is how long that will occur, because in many instances, the vast majority of those customers shift their preferences, as Greta said, to new packages. And so it varies, and it's not something that we would be able to provide a specific length of time for as it relates to every single package and offering that has been made available to existing customers from Cox.
I believe, Mr. Falk, that you said some previous Time Warner customers maintained their packages for 9 years, which would indicate that they were interested in keeping their current packages at their current rate. My question is whether the plans being made now are going to be reflective reflective of the plans that were made during the Time Warner Cable merger, plans that changed, as you indicated, that some of those plans have been discontinued.
I'm going to object on the same basis that the chair just referenced. Past is not necessarily prologue, and the witness's response is that if a customer wants to retain it, they can retain it.
I would sustain that objection. I think this is, in my view, it would be very difficult to tell which packages were discontinued because of lack of customer interest, as opposed to a unilateral decision to get for the company to drop it. So I will sustain that objection.
Okay, I will move on. This next line of questioning is with regard to franchise discounts for specific populations. This question is for both companies. Can representatives from each company please describe for everyone's understanding here what kind of senior discounts or discounts for other vulnerable populations, such as low-income consumers, individuals with disabilities, or veterans that your company offers in certain franchise areas?
You're asking about cable television discounts, correct? Not,
am.
not discounts associated.
Yes, exactly.
Yeah. As far as I know, we don't have any.
Can we take this as a late filed exhibit? I happen to know they exist elsewhere.
Well, the witness answered the question. So, this is another instance. If you say you happen to know they exist elsewhere, there's no foundation in the record for that other than your statement. So it simply is not probative.
You're asking me about in Connecticut, right? Whether we have senior discounts in Connecticut?
I'm asking for general information for everyone's understanding about what kinds of senior discounts or other discounts that your
Oh.
company offers in certain franchise areas,
I'm,
in general.
Excuse me. In Connecticut.
No, in
No.
general.
I object. Connecticut's the only thing that's relevant here.
Excuse me, may I respond? I'm sorry that this is going on. Today, it's not my fault. In any event, what I'd like to say is that we talk about national pricing. That's all we've heard. Don't worry, national pricing. So I think it is very relevant to know generally what discounts are available. Ms. Ash has been very gracious in saying, we don't want to put you on the spot today, that you may submit it as a late filed exhibit or.
I interpreted her question when she said franchise requirements to mean that she was asking me whether we have franchise required discounts in Connecticut. If her question is whether we have franchise discounts elsewhere, that's a different question.
Mr. Falk, I don't mean to interrupt you, but we understand what you're saying.
Yeah.
But our question was much different than that.
I claim the objection. If the question wants to be limited to Connecticut, we can respond to that. What the company might do in some other jurisdiction is not relevant here.
If I may, my question was background as to an industry norm. I believe discounts are negotiated as part of franchising all around the country. I'm just looking for a little bit of background here before I move into my next questions, which are very Connecticut
And
specific.
now I've got a different objection because there's nothing in the record regarding industry norms.
Oh, I'm going to overrule. I think the applicability of the question can be taken into account when we consider our decision. And if we can bring up issues of jurisdiction in correspondence or in briefs. So if you want to proceed with your question, and if you cannot provide that information today, the information as to those specifically delineated discounts in other franchise areas could be supplied as late filed Exhibit 11.
With the overruling of the objection and understanding the question, I'm certainly happy to provide a response to it. Want to be as transparent as possible. We have over 10,000 local communities that we serve. The vast majority of them do not have senior discounts that are required as part of those franchise agreements. There are a small number of instances in which, principally instances in which we acquired a franchise through an acquisition where the predecessor had entered into a senior discount, and we continue to have those today. There are a small number of older legacy franchises that Charter entered into as well that had senior discounts for a limited package of services. But again, the vast majority of the communities that we serve do not have senior discount obligations requirements in them.
But you should be able to provide the information about those areas in which those discounts are available.
Well, I mean, by state or you're saying by individual? Again, we have 10,000 local agreements. I think they're aware, and the information about where we have senior discounts is available on our website. So there are links in our rates that you can drop down and see which states they're applicable to. I don't think that we have that information provided on a municipality by municipality basis.
So would it be acceptable to see states where these senior and other low-income discounts are available on a state-by-state basis as opposed to very distinct municipalities? So more generic information.
I would be willing to make the question perhaps a little bit easier to answer.
I'm sure
By-
that would be welcomed.
Perhaps the highest percentage discount of a senior discount currently available to consumers in a specific franchise and where that would be.
Certainly, we can provide that.
And perhaps,
So perhaps where the highest discount would be for those populations you delineated and where that takes place. Is that correct?
yes, that would be perfect. And we can include discounts that are applicable to all of the following designated populations: seniors, low-income consumers, individuals with disabilities that meet certain criteria, as I'm sure are negotiated, and veterans.
Happy to provide that.
Thank you.
Thank you.
And can I presume that you would pose the same question to Cox?
You may.
And our answer is the same. I think as it relates to Connecticut and to video programming, we do not have any discounts applicable to those groups. And I'm going to take the other as a late filed. I think I know the answer, but I don't want to guess.
Thank you.
What were the numbers? The late file?
That would be 11 for Charter and 12 for Cox.
Thank you.
Charter, this question is for you. Please reference OCC 161.
Can you provide me a moment to get there?
Absolutely.
Okay.
Can you confirm whether this sample bill that was produced in response to this interrogatory was sourced from Connecticut?
Okay. Yeah.
Your Honor, we're happy to take this as a read-in or a late file.
Actually,
Yes, it is sourced from a Connecticut customer. If you look at page 3 of 4, you will see that it indicates the franchise administrator being the Connecticut Public Utilities Regulatory Authority at 10 Franklin Square in New Britain, which I think is where we are today. It also indicates that customer service may be provided to this customer at 14 Churchill Road, Unit B5 in Newtown, Connecticut, which I think also indicates that the bill is sourced from a Connecticut customer.
Thank you. I'd like to direct your attention to the portion of the statement under spectrum terms and conditions of service, which reads, in
What
accordance.
page?
Have to find it again.
Oh, yes, I see it on page 3.
Thank you. Which reads, in accordance with the Spectrum terms and conditions of service, Spectrum services are billed on a monthly basis. Spectrum does not provide credits for monthly subscription services that are canceled prior to the end of the current billing month. Charter, can you confirm whether the information printed on this Connecticut sample bill describes Charter's current billing beyond cancellation of service policy in Connecticut?
There are certain subscription services in Connecticut that we are required to prorate at the end, if a customer cancels before the end of their term. Some of those services would certainly be services that are provided to this customer in this particular bill. I haven't looked closely enough to determine whether it's all the services that are provided, but to the extent that it covers services that are covered by the state's proration law, it would seem to indicate that that information is not correct.
Thank you. And to be clear, I'm not seeking a legal opinion here, but wondered, could you provide any explanation of the apparent discrepancy between the policy stated on the sample bill and the law in Connecticut, which requires a prorated adjustment if a consumer cancels service prior to the end of the billing cycle?
I mean, the only thing that I can,
Services that
the
are-
only thing that I can suggest to you, maybe an explanation for it is that a customer who cancels their service, for example, might not want a credit for service and may want a refund because they're no longer a consumer of the company after that. And so I don't know whether that language reflects something different or whether it's an error in the bill. But I can tell you that we comply with Connecticut's proration law as it relates to the services that are covered by that law, which is, as I recall, the cable television services would not include internet services or other services that are offered by the company to consumers.
Thank you. So to
Yeah.
confirm, the current policy is that for video services, the unused service would be either credited to or issued as a refund to the consumer if the cancellation was prior to the end of the billing cycle?
Well, I'd suggest to you, Ms. Ashley, it's not a policy, it's a requirement that exists in law in the state. And certainly our policy is to follow the law.
My concern is that the policy is not adequately described on the billing statement. So I'm hoping you can tell me if perhaps that will be updated in the future.
You made that point, and I acknowledged that the information provided in this bill may be incorrect, and that obviously we would correct the bills if, in fact, they continue to provide language that's not correct. Again, I'm not a lawyer. Well, I am a lawyer, but I'm not. I'm not playing one here on TV. But to the extent that that information is wrong or misleading, of course, we would update it to ensure that it is correct.
Thank you. Mr. Falk, this next question is for you as well. Please refer to OCC-83. In this question, Charter was asked to identify and describe all customer billing errors discovered to affect Connecticut consumers, 50 or more, between 2020 and present. It also asks that you include the nature of the error, the number of affected customers, and the services that the billing error affected, and whether refunds were issued to affected consumers. While it appears as though the same question was answered fully by Cox, it does not appear to have been fully answered by Charter. And I'm wondering if you can supplement the record here today, confirming the answer to those questions.
I think the response speaks for itself, but if you feel that it didn't fully answer your question, we're certainly willing to take that back as a late file exhibit.
Thank you.
If you could restate your request to Charter, please. This will be late filed Exhibit 13.
Yes. In reference to OCC-83, wherein Charter was asked to identify and describe all customer billing errors discovered to affect 50 or more Connecticut consumers between 2020 and present. It also asks that you include the nature of the error, the number of affected customers, and the services that the billing error affected, and whether refunds were issued to affected consumers. Please supplement the record here by confirming whether Charter experienced a billing error or errors affecting more than 50 Connecticut consumers between 2020 and present, and the additional information as answered by Cox.
I'm sorry, is that a different question than the question you previously asked me?
It should be right around the same.
I'm sorry?
It should be just about the same.
She's,
I don't know what the differences are.
I think if I may, Ms. S, what you're looking for are the actual instances where there were billing errors that affected more than 50 or more customers.
Thank you. Yes.
Yeah.
We can provide that information for the services that are regulated by the authority.
Okay. When you're ready? Charter, this next question is for you as well. With regards to termination for non-payment, can you please walk me through your company's policies, specifically those preventing the disconnection of service to a subscriber for non-payment of a disputed bill during the pendency of a complaint?
Yeah, I'm going to turn that response over to Ms. Kim, ask her to provide that information.
For billing disputes, our live customer agents are available 24/7, 365 days a year in order to respond to questions and to research real time. If we are unable to provide an answer, then we do have specific escalation procedures where we will be able to ultimately resolve the customer issues. In terms of non-payment service interruption, there is a schedule with which we follow. There is a payment due date, and then there is a grace period for us to remediate and to arbitrate on any disputes brought to our attention. If the dispute is deemed valid, we will correct the bill, provide the necessary credits if needed in order to resolve the issue for the customer. And there is a grace period of time before any soft interruption window before the full service interruption.
Thank you.
Also point out that we provide information on our bills about where customers who have complaints about their bills can go. And I don't have the exact number of complaints that are referred to Pura in front of me. But you're talking about what amounts to a handful each year, which I think is indicative of the fact that our billing practices are sound and that we are transparent with our customers in terms of how we bill them for their services.
And to clarify, these accounts that are subject to a dispute, do you consider only complaints filed with Pura to meet this requirement for being under dispute, or also complaints that are escalated internally?
So in my response to your question, I did understand it to mean anytime a customer raised a concern and brought it to our attention as a charter internal matter, and not necessarily those that are brought to Pura's attention exclusively.
Okay, thank you.
Yeah, my response wasn't intended to suggest that there aren't other means in which a consumer can bring a complaint. I was simply making the point that we receive, despite the fact that our customers have the option to go to the various regulatory authorities to bring complaints with regard to our billing practices, that very few of them, in fact, do that each year, which I think is demonstrative of the fact that we are transparent with our customers about our pricing and that we provide good customer service. Thank you.
Thank you for clarifying. Can you tell me if consumers receive a certain indication from the company once their account has been flagged as having a dispute?
I'm sorry, Ms. Ash, can you repeat the question?
Sure. Do consumers receive an indication from the company that their account has been flagged as being, under dispute? Do they have any way of confirming that if they call in and complain, that their bill is actually subject to this dispute mechanism?
So you're asking, is there some form of acknowledgement on the company's part when a customer registers what they believe to be a dispute?
Exactly.
I think when a customer calls to make a complaint, that they know that they've made a complaint. So I'm not sure I understand the question that you're asking me. You're asking if we flag for the customer that we've received their complaint, they're in fact making the complaint.
Yes.
I think, and I don't want to put words in anyone's mouth, but once a customer files a complaint, does the company then say, we have received your complaint, we are investigating the procedures, and we will get back to you as soon as we reach a decision? Is that the sort of thing you're asking about?
Yes, and confirmation that during the pendency of that dispute, their account isn't going to be shut off for a disputed charge. It's a specific right that the consumer has. And I'm trying to determine if the consumer can confirm from the company that they're able to take advantage of this right.
So as I indicated previously, the vast majority of the billing disagreements or complaints that are brought to our attention are resolved real time with live agents. So in that case, there would not be an additional notification, but in the instances where there are escalated complaints that require further investigation, we do have our charter corporate escalations department, and there would be a formal outreach and acknowledgement of the receipt of the complaint.
Thank you for the additional detail. I would also like to confirm, as this is a right specific to Connecticut consumers, and you have a lot of national call centers, how is the account flagged as being complaint pending or preventing the disconnection of service during the pendency of a complaint?
Well, we have tools that are made available to our call center employees that relate to specific requirements on a state, regional, or franchise basis. I can't answer for you, draw a legal conclusion as to whether or not this is a right or not that is required as part of our cable franchise, requirements in the state. But if it is, that information is provided through the tools that are made available to customer service agents in the same way that other unique circumstances related to customer billing practices are identified for those agents.
Thank you. So to confirm, and then I'll move on to Cox, the account can be flagged to prevent a disconnection during the pendency of a complaint for the amount that's in dispute?
Can it be, or is it?
Both.
Well, can it be? Yes. Is it would depend on what the regulatory requirements are in the state of Connecticut for the services that the customer is subscribing to.
So if it is dictated by Connecticut statute that a customer be notified of acknowledgement or terms and with regard to discontinuation during pendency, that would be supplied.
Correct. Yes. I mean, we follow the law that's applicable in the states where we provide service. There's no record of us or complaints that I'm aware of being made about us not following the law, right? Earlier, Ms. Ash brought to my attention something in a bill that looked inconsistent with a requirement in state statute. Certainly not how we're, whether it's written incorrectly or not. It's not how we're engaging from a standpoint of our practice, and sometimes mistakes are made in the information that we provide, and we're glad to correct that. But we've never been the subject that I know of a complaint from Pura or OCC or the Attorney General's office or any other regulator about not properly flagging an account to prevent delinquency where there's a dispute. So if that's a requirement, yes, we're complying with it. If for some reason it wasn't complied with in a particular instance, or a customer service agent got that wrong, of course, we'd be happy to make a correction that, as we would in the ordinary practice. We're not here to try to skirt the law, right? We want to comply with the law,
Okay.
and we intend to do it.
Right. Thank you, Mr. Falk. And with apologies for Attorney Bogan if he thinks this is too granular, I do have a question. One, I am extraordinarily pleased to see that you have all 100% based customer service agents. Two, that they're available 24/7. But what agency are these agents given to resolve disputes on the first call? Are they given sufficient flexibility and, let's say, independence to resolve those complaints? Because I know one of the things that is very concerning is when you hit the brick wall and you want to take it higher, and no, I can't. So I'd just be curious as to, I phone in, I have an issue. How is your agent going to approach that? And if I'm really difficult, how much ability do they have on their own to resolve it? And then say, okay, on the interest of keeping a happy customer. And again, apologies to Attorney Bogan if this is too granular.
If I may, Commissioner, for what it's worth, and I hesitate to say this, but in 39 years, I've never objected to a question by a commissioner.
See, I learn something new every day. So if somebody could respond to that?
I'm going to let Ms. Kim answer your question. We have thousands of agents, as you know.
Yeah. I'll make it simpler. What percentage of your customer complaint calls are resolved on the first call? And I'll take that later on if necessary, because I think that's really an indication of how well the system is working. And I would pose that to both.
I have to refer to Pura 17, which I think is where the response to that question.
Okay, you'll forgive me for not having poured through every single
I-
piece of
I-
Pura
I don't-
17.
I'm in the same camp. I had to ask him where it was, so certainly not intended to be a reflection on your review of the information.
And I'm happy to take that as a read-in later if we can't identify it right away. I'm in the interest of moving this along, but I do think how a company deals with its customers is obviously relevant to the discussion at hand.
Commissioner.
First call resolution.
I'm sorry, Mr. Falk. The information appears to be in Pura 17. That is a confidential response, but I believe it's already in the record.
All right, well, I will look at that. And I'm not asking of you to obviously something that you filed confidentially. But again, getting back to perhaps my more qualitative question, the ability of your agents to resolve disputes.
I mean, if I may, we are very proud of our 100% US-based internal customer service force, and we provide them extensive training in order to provide resolution for customer issues on the first touch whenever possible. It is a metric that we look at very closely, and we are constantly providing additional training in order to enhance their ability. And we do find that the vast majority of our customer interactions are handled successfully without a repeat call and without needing to transfer to another party. That said, there are specific instances where the issue is more complex or requires further research than the agent is able to do while on the phone with the customer. And in those instances, we do provide additional support, such as leadership support that is available to the agents and to customers, also 24/7, 365 days a year, as well as other follow-up measures where we will call customers back in the rare event that it is needed.
Thank you.
Just would like to add that while I can't provide the specific confidential responses, the first call resolution rate is quite high, and that resolution rate has increased since 2020, which was the period of time in which the question was asked. So between 2020 and 2025, that rate has gone up further than what was already, I think, a high rate of first call resolution.
Thank you. And would Cox care to comment?
Briefly, I won't go into as much detail as Ms. Kim, but with that information is also available in the record at OCC 211 and also filed confidentially, but I'll just direct you there and
All right.
let it speak for itself.
All right. Thank you. I'll hand it back to Office of Consumer Counsel.
I have a follow-up question, actually. Is the data that's provided in those confidential filings, is that Connecticut specific or is that national?
Yes, that was Connecticut specific. For the charter responses for,
Mhm.
Responses that were provided, all resolutions specific.
Yes, on first call resolution.
Those are on a national basis for each year between 2020 and 2024. And they likely include both first call resolution rates associated with regulated and non-regulated services.
Okay. Cox, is yours national or state specific?
We are having that same conversation. We are inclined to believe it's national, and we are happy to follow back up.
Is it possible to provide Connecticut specific data for first call resolution?
I don't know for sure. Happy to take that as a late file exhibit and provide if available.
That would be acceptable.
I don't know if we have those figures separated by state. Certainly happy to provide them if that information is readily available.
Thank you.
Be late filed exhibits 14 and 15. So first call resolution rate for Connecticut, if available from both Cox and Charter, correct?
Correct.
Cox answered first, so they get 14.
I put them down on 14.
Commissioner Cheeseman, could they include both national and Connecticut specific so we can see those together?
I believe they've already supplied the
Or
national and the
like in
confidential
the
filing.
In the addition, just for comparison. Oh, yeah, we can go back and do it. Thanks. Yeah, I realize they did. It's just so we could show relative performance.
Yeah, no, I think that's fair. We can clarify that 211 in our case was national and here's the state, or vice versa.
And Cox's numbers are also available under Pura 17. So we'll take what's available under Pura 17 and, clarify that it's Connecticut or national, and then provide the comparisons, if that's okay.
Thank you.
Just to be clear, Attorney, Bestor's comments suggested that if it's Connecticut, they're not going to apply national. I think we would like to see both national and Connecticut. No objection to that.
Understood.
Thank you.
If we're ready, my next question is for Cox, referring back to our conversation about how the company handles staving off disconnection during the pendency of a complaint. Do your policies differ from those described by Charter for preventing the disconnection of service during the pendency of a non-payment complaint over a disputed bill?
To the best of my knowledge, they do not.
And can you tell me, does your company flag the account or put a hold on the account to stave off disconnection during the pendency of a complaint?
I am going to have to take that as a late file. I do not have firsthand knowledge of that.
Okay.
So this would be acknowledgement of the receipt of a complaint and that it's in process.
That's my next question, actually.
So if you could just be clear about what this late filed exhibit 16 rather would be with regard to Cox.
How does the company flag an account or put a hold on the account to stave off disconnection during the pendency of a complaint? And as a follow-up in the same LFE, can you tell us if the consumer is notified that the account is pendent a complaint, if it's been flagged?
So, because I think that, so just so I understand, so your only customer notification question is as it relates to a pending disconnect flagged account.
Yes, essentially, has this account been protected pursuant to the complaint being lodged? And the consumer knows that they're not going to be shut off until it's resolved.
Understood. Thank you.
Okay, we're going to shift gears a little bit. Charter, we can start with you. Does Charter currently file an annual document traditionally known as a rate card, which provides the pricing for video packages, equipment, and associated fees with Pura? And if so, in what docket?
If I may, I'm going to object because that question was asked in interrogatory to which the company responded. All of the cable operators are required to make that filing.
I think that part of the issue, Attorney Bogan, is, if I may respond to him through you, Your Honor, is that we can't find them. That's why your question was, in what docket are they filed and where are they?
Oh, David? So So we provided as a link to the information that we provide to Pura on an annual basis. We provided as a link to the annual rate card that is provided online as part of, I believe it's the annual Pura filing. And then we offer the rate card itself, the hard copy of it, in an undocumented filing that we make. And so undocketed, not undocumented, undocketed. Thank you. So it's both available on our website and provided to Pura with a link on an annual basis in our report. And it is also submitted in hard copy in undocketed correspondence.
And to keep it moving, I will say that it's my understanding from our team that that's the exact process we follow as well.
Is that different than the information that we provided to you in OCC 303?
If memory serves, and forgive me if it doesn't, but I think that was asking for those documents to be included in the record. I don't think we asked where they were filed regularly.
Okay, so we're ready to move on now that you
Are.
know where to find. Okay, thank you.
Mhm. Forgive me, these next questions are basic. I just want to make sure I have an understanding. Cox, this one's for you. You have a certificate of cable franchise authority in Connecticut, correct?
That is my understanding, yes.
Mhm. And is it your understanding pursuant to that certificate that you are providing CATV services in Connecticut?
And I'm not specifically familiar with how CATV services are defined in Connecticut statute, but to the extent that generally refers to cable television, then the answer is yes.
Thank you. And Charter, same question to you. Do you provide CATV services in Connecticut?
I'm going to object to the question because it calls for a legal conclusion as to what qualifies as CATV service under Connecticut statutes.
Would you like a description to better answer the question?
Could certainly try.
Okay, thank you. I believe CATV is defined as any system operated in, under, or over any street or highway for the purposes of providing community antenna television service for hire pursuant to a certificate of public convenience and necessity issued by the department.
Again, I'm going to object. It really calls for a legal conclusion.
I'll sustain the objection.
I didn't get a chance to respond, Your Honor, but it's very basic.
I think that I think there are better ways we can spend our time, and I'm sure the Office of Consumer Counsel has some very important questions they'd like to pose as we proceed. Thank you.
Thank you. Shifting gears again, as a little bit of context about this conversation, in the recent settlement for the Verizon Frontier merger, which involved similarly two major communications companies operating in different service areas of Connecticut, and which upon closing will allow for a combined lion's share of the market, Pura approved certain conditions which ensured the public interest would be best served by the transaction. And we want to ask a few questions about the positions of the parties here regarding these conditions and their commitments to the public interest in Connecticut.
Well, you can start asking, and I'm sure if people object to them, we'll hear about it.
Thank you. Pura approved that the combined company under Verizon would submit service quality reports for wireline voice services. And Verizon agreed to differentiate the quality of service data by unregulated and regulated technology when reporting the averages. And Verizon also agreed to the requirements for exception reports regardless of technology type for that wireline voice data. Will the new Charter and Cox agree to file those quality of service reports for their wireline services as Cox currently does, but Charter currently does not?
We're not going to make commitments specific to the requests from the Office of Cable Television. The Office of Consumer Counsel. We provide our services in accordance with the law. We have a very good track record of service in the state, which is undisputed. And there's no basis for OCC to request that we provide information beyond the information that we're required to provide to Pura, and that has been the subject of very strong support for our services and operations in the state.
Let me make one thing clear, Your Honor. We are not asking the commitment to the Office of Consumer Counsel. This is a commitment to the state of Connecticut through the Public Utilities Regulatory Authority. I just want you to understand these questions are not our commitment. This is to the people of the state of Connecticut.
If I may, this really goes to what I said at the outset. We operate in a largely unregulated market. And the problem is that the authority only has limited jurisdiction over the services that Charter or Cox provide. There are numerous other market participants who are not shouldered with that sort of burden, having to file those sorts of quality of service reports. And that's why it's objectionable to the company that they're being treated than other market participants who are not.
That's a legislative issue, Your Honor. It's not, And it's not really up to the companies to say what is regulated and what is not.
Well, and I appreciate the question, but as this commission has not yet reached any conclusion as to the eventual disposition of this application, to ask a company whether or not it will comply with regulations and requirements that we might put on before actually seeing them, I do think is perhaps a stretch. I dare say if this commission decided to include certain requirements, subject to our statutory control over the operation, and that were a condition of the merger, if the companies wish to go ahead, they would certainly view it in their interest to comply. But I think this is speculative and based on another agreement. And as far as I'm concerned, that I respect their decision not to answer that particular question, but having made clear that we have in no way handed down a final decision. And as we are guided by our statutory requirement, we will abide by that in any final decision we issue.
If I could just chime in, Mr. Bogan, you acknowledge the difference between price regulation and change of control regulation, correct?
Yes.
Yeah, thank you.
Can I just offer one more?
Is it a quick comment? And then after your comment, Mr. Falk, we will take a 15-minute break.
What I can commit to you is that we'll continue to do the things that have made us be recognized by Newsweek as one of the America's most trusted companies in the country. I can commit to you that in terms of our customer response times, we will continue to make improvements that we have in the past. We will work hard to do that because that's good service for our customers. Our average hold times with customers have reduced by over 75% from 2020 to today, which you can see in that confidential filing. The average number of abandoned calls has also reduced almost threefold from 2020 to today. The first call resolution for customers has increased by more than 2.5% since 2020. Our same-day scheduling, as outlined in Pura 18, has increased dramatically, while next-day and two-day scheduling has declined precipitously. To suggest that in some way we are a similarly situated company to the company that you referred to earlier isn't accurate. And so the commitments that we make are to our customers and to follow the law, and we do it appropriately and we do it with distinction.
And I think we really do appreciate the numbers. I think data is very important. And what quality of service standards measure is that data about how you're responding to customers' needs with a service that consumers use to dial 911.
And after our discussion, thank you, Office of Consumer Counsel. Thank you, Mr. Falk. We will recess for 15 minutes or so and reconvene at 10:45.
Thank you.
All right, it is 10:45 and we will reconvene this evidentiary hearing. Office of Consumer Counsel.
Thank you. Charter, to you. Charter, please confirm what technology you use to provide wireline voice service to Connecticut customers.
Principally voice over internet protocol.
Thank you. And Cox, can you confirm what technology you use to provide wireline voice service to Connecticut consumers?
It's my understanding we also use voice over internet protocol primarily.
Thank you. Please reference OCC 230. The response indicates that Cox charges a 1 cent state telecommunications relay fund fee to phone customers. Can you tell me to what state entity is the profit from that charge remitted?
Yeah, I've not found that response yet. Hang on just a second. Can I have a second to confer with my team? I'm sorry.
Sure.
The go-to. Right. I apologize. We're gonna have to get back to you on that. There's a little uncertainty as to who exactly the funds go to.
Thank you. I can take that as a late filed exhibit.
So that will be late filed exhibit 17 on the destination of the,
The state telecommunications relay fund fee. To what state entity is the profit from that charge remitted?
I would just characterize it as not a profit, but the collected fees to what?
it's a pass-through, I presume.
Yeah.
Okay.
And Charter, do you currently remit funding to support the state telecommunications relay fund? Either, on your own voluntarily, or is it a pass-through cost on consumer bills?
I'm going to object only because it's a compound question. So perhaps first, ask the first question.
I can rephrase. Charter, do you remit funding in support of the state telecommunications relay fund to any state entity?
We remit the federal telecommunications relay service fund in response to OCC 86. We set forth the various fees and surcharges that we collect and remit to the appropriate authorities.
So I'm sorry, can you confirm whether there's a pass-through charge on charter consumer bills in Connecticut for the state telecommunications relay fund?
The fees and charges that we remit to the state and federal authorities are set forth in that response, which include 911 fees, federal communications regulatory fees, the federal excise tax, the federal universal service fund, the federal cost recovery fee, the reimbursement of gross earnings, sales taxes, and PEG fees.
So am I correct to understand that the state TRS fee is not a pass-through cost on consumer bills in Connecticut?
And object only because the response speaks for itself, and Mr. Falk has indicated those are the programs to which the company provides funds.
Okay. This next question is for both companies, whoever would like to answer. Could you please provide an explanation of the difference between an FCC fee, which according to OCC 86 and previously mentioned OCC 230, Cox charges but Charter does not, and the federal cost recovery fee, which Charter charges but Cox does not?
Is the question asking for the witness to describe legally required fees under the relevant statutes?
I'm not sure they're legally required fees, no. They're line items on the consumer bill. So if a consumer called you up and said, what's the difference between an FCC fee and a federal cost recovery fee, what would you explain to them?
Would be a fairly technical answer, but I would say that the Federal Communications regulatory fee is a fee that the FCC adopts to fund its activities, which are assessed upon entities regulated by the FCC, including Charter. The FCC determines the regulatory fee pursuant to a report and order, and Charter is required to pay that amount each year. In terms of the federal cost recovery fee, I would indicate that the FCC establishes a mechanism to fund interstate telecommunications relay services, the administration of the North American Numbering Plan. At this point, their eyes would probably glaze over, but I would say the shared costs of local number portability administration and requires certain providers, including Charter, to report each year on the revenues they receive from certain offerings. I would say that the FCC also uses this reported revenue to calculate and assess interstate telecommunications service provider regulatory fees and the administrators of the various entities that I mentioned before, the North American Numbering Plan, the Local Number Portability Administrator, and the Telecommunication Relay Service Administrator. And so that's what I would provide to them as a response. So many words.
Thank you.
Yeah.
For Cox, according to your response to OCC 230, you do not charge a federal cost recovery fee. Is that correct?
That is what I see in the response as well.
Okay. And Charter, can you confirm whether you stopped billing consumers the FCC regulatory fee in January 2025?
We did, yes.
And Cox, you still charge consumers the FCC regulatory fee?
If you are referring to the item designated as the FCC fee and the fixed amount, yes, it's my understanding we still collect that fee.
Mhm. Cox, can you explain why you charge this fee currently?
It's my understanding it is a fee imposed on our providers by the FCC, and so we collect it from our customers and remit it to the FCC.
Mhm. And Charter, can you explain why you don't any longer charge consumers the FCC regulatory fee?
I can't tell you the reason for that, Sumit. I don't know the reason.
Will Cox be directed to no longer charge that FCC fee following the close of the transaction, as Charter has discontinued charging that fee?
I think I think we should object to that. We object to that question as it directs, it says that after the transaction that it will direct Cox to. I think that should be referred, could that question be rephrased as to what the combined entity intends to do following the transaction?
Can you clarify what does the combined entity intend to do following the close of the transaction with this fee at this time?
I haven't had a conversation with anybody about what our integration plans are. If we voluntarily discontinued it, that would obviously be different than if we were legally required to discontinue it. Certainly, if there are legal requirements associated with the discontinuation of that fee, we would, of course, follow the law.
Thank you. Okay, I'm going to turn the questioning over to Attorney Cohen. Thank you very much.
Staff Attorney at the Office of Consumer Counsel. Nice to see you all back again. And welcome, Ms. Kim. Mr. Murphy, as I promised you, I had a few questions for you. So, and again, if I didn't quite catch it the other day, because your testimony was pretty good and fairly helpful.
Commissioner, this is.
What is the current excuse me, I'm asking a question, Mr. Bogan.
I'd prefer.
What is the current free cash flow of Charter Communications, and what percentage of earnings before interest and taxes is the current free cash flow? I'll break it down into two questions. What is the current free cash flow of Charter Communications?
It's nice to see you as well, Attorney Cohen.
Thank you.
I believe my testimony the other day provided that the last 12 months free cash flow of Charter as of 9/30/25 was approximately $5.2 billion.
I'm sorry.
Approximately $5.2 billion.
Thank you. And what percentage of EBIT
Of EBIT.
is that current free cash flow? Do you have that available?
You're going to need to give me a moment on that. I generally think in EBITDA terms, not EBIT terms, so bear with me.
I'll take EBITDA.
All right, just give me a moment.
So you take EBITDA, right?
Yeah, I still need a moment for
Yeah,
that too. So our LTM EBITDA was 22.8 billion over the same period. So you asked for a percentage, yes?
Yes, sir.
Yes, real-time calculations. Put twice for confirmation. It was approximately 19%. Free cash flow to EBITDA.
Thank you, Mr. Murphy.
Mhm.
Have you made any projections, or has Charter made any projections about free cash flow of Charter and its percentage of EBITDA post-merger?
We have provided in the proxy some forecasts. If you bear with me, I will also get to.
If you need time, we can take it as a reading.
I can probably read that one into you if that's better for the efficiency of the proceedings.
Okay, because I have another question for you.
Okay, let's keep going and we'll take that as
Okay.
a reading.
We talked a little bit about pledging of assets. To whom or which entities are the assets of Charter Communications Operating LLC currently pledged? I'll say it again. To whom or which entities are the assets of Charter Communications Operating LLC currently pledged?
So those pledges are related to our financings, at least the ones that I am aware of. Those financings at CCO are what we call secured. They're secured by the assets. That security is provided to two sets of creditors. Our credit facilities, our bank lines, provide that security to a series of banks with whom we have relationships that provide those facilities. And then the vast preponderance of the debt is institutionally placed to market participants seeking yield and return for their investors.
Okay, thank you. And assuming the merger of Charter Cox gets all the the proposed merger gets all the federal, state, and local approvals and ultimately closes, I believe, estimated the second quarter of next year. I'm assuming, and will you please confirm, the assets of Comm LLC will be pledged under the same financing arrangements? Is that?
So I think consistent with my testimony the other day, it is our current intention that through a series of transactions, those assets would be contributed down underneath CCO. And both the assumed Cox debt and the assets would mirror what we have currently and would have a similar pledges to a variety of institutional holders of our debt and the banks that provide our credit facilities.
Thank you. That's sufficient. I just have one more request. We would request as a late filed exhibit, the joint applicant's response to the Rhode Island Division of Public Utilities and Carriers in docket number D-25-18, request Division 1-7 on pages 13 to 15 of your responses to those concerning your answer to the Rhode Island PUC when they asked you the question about pledging of Comm LLC's assets. We would like that as a late filed exhibit, so we don't have to go through a lot of detail. You've already answered the question there. We would have asked that interrogatory, Your Honor, had we known that there would be a pledging of assets associated with that, but I do not believe it was disclosed in the application. So we want that. I know that there was a public version that was redacted. We would like the full version, the non-public version of that response to Division Data Request 1-7. And if it's considered to be proprietary or confidential, you can submit it under protective order.
So I don't have an objection. I have a point of clarification. So are you asking Attorney Cohen that they provide the information that was provided to the Rhode Island Commission in response to, I think you said something?
A data request.
And the data request again was?
Well, I'll go through it all.
Oh, I just want to make sure we're going to give you what you're looking for.
We're looking for what the applicants, I believe they jointly filed a data request DIV Capitals 1-7 concerning the Rhode Island PUC's question about the pledging of assets of Comm LLC.
That will be late filed Exhibit 18.
Thank you. Thank you, Your Honor. Attorney Bogan, did I answer your question? Are you all set? All set. Thank you. Questions about the role of the parent company versus the role of operating companies. I think it's important for us to know because obviously the operating companies are the ones that provide service in Connecticut. Carter, can you tell us what decision-making authority does your operating company here in Connecticut have, and where do they have that operating authority? Or is basically everything done on a national basis to standardize procedures?
I'm not sure I'm fully understanding your question. Are you talking about
Number of employees, pricing, CapEx, capital expenditures, things of that nature?
are they made at the Connecticut operating entity level, or are they made at a level above
That's
that?
a good way to rephrase it, sure.
Yeah, no, they're not made at the Connecticut operating entity level, except as it relates to compliance with Connecticut requirements. But there's the decision-making of that occurs at a level that is above the operating entities.
So like in the old days, when you started at Cablevision, sir, you had local cable systems offices and whatever. Did they have more responsibility for operational decisions back then? Do you recall? Or, I mean, just in a very global.
I understand your point. I'm not sure it was associated with the time period that I joined Cablevision. I joined them in 1998, and largely by that time or shortly thereafter, I don't remember exactly, the sort of general manager structure of cable systems, which is, I think, what you're referring to, where there was a general manager who had operating, P&L responsibility, marketing, et cetera, occurred at a system level. I believe by the time I arrived at Cablevision in 1998 or shortly thereafter, we discontinued that, and there was more of a centralized management structure. And a similar centralized management structure has been in place at Charter since I've been here, and I'm sure before that as well.
Thank you. On October 21st of this year, the Wall Street Journal reported that Charter Communications was laying off 1,200 employees, over 1% of its workforce, mainly in corporate and back office functions. Have those reductions in force occurred yet? Are they occurring?
First, I would say I'd be remiss not to say that the layoffs that you referred to and how they relate to employees and their families is, always an issue of concern for us, and a decision that we didn't make likely. I'm sorry, make lightly, I should say. As far as I know, all of those decisions have been implemented. Employees who were the subject of those job eliminations, which largely occurred outside of Connecticut, received lengthy severance packages that were tied to their tenure, and other transitionary services to try to help them in their efforts to move forward in employment.
As the Wall Street Journal reporting incorrect, because it says, and I'm reading here, from the cuts based on the reporting are primarily at the company's Stamford, Connecticut headquarters and elsewhere, it does say.
I'm going to object only because the question is essentially being asked and answered. I believe he said it was primarily outside of Connecticut.
Okay. Yet I'll yield to that. I won't. I'll ask it in another way. Wednesday, there were a lot of discussions during your testimony you had with the commissioners that were presiding here about employees, employee retentions. You had a lot of figures that you put out there. Did those figures include the 1,200 employees who lost their jobs as a result of this decision, or?
They reflected, first of all, I don't recall giving exact numbers. I think I used approximations. I said we have, for example, approximately 2,000 employees in Connecticut. The information that I think we provided in our discovery responses predated those job eliminations. And so the information that's provided in the discovery responses certainly predates those positions being eliminated.
Okay. Given that information, I appreciate your candor on that, Mr. Falk. OCC requests a late filed exhibit that provides a current updated account of charter employees in Connecticut who work out of the Stamford corporate office, and an updated count of charter employees who work out of other locations in Connecticut, such as Newtown and Willimantic.
I think you're asking for numbers updating the prior requests at the same categories of requests that you made previously, but for the period after those job eliminations.
Right, yes, and we do want, again, to break it down. Stamford, Newtown. I don't think Winstead you have an office anymore, but if you do, wherever you have Connecticut operations, and you can probably put them all together.
Yeah, I think we did break it down like that in our prior
I think you did as well,
responses.
yeah.
And so I'm sure we can do that in our updated responses that they'll, I believe they were a confidential filing. And so I'd imagine that we
If
would,
it's confidential, we'll honor that, obviously.
If I may, Commissioner, it appears as though that was requested and responded to in OCC 35. So this would be an update to the company's response to OCC 35.
All right, understood. Thank you, Attorney Bogan. Thank you, Attorney Cohen.
Thank you. I know there was also conversation about whether attrition at the company, what was the reason for that? But this wasn't the only reduction in force that I think Charter imposed. And according to reports and filings that were made at the FCC this week by other entities, in June 2025, did Charter announce planned layoffs of 1,200 workers at 4 call centers? And is that announcement separate from the 1,200 that were reported in the Wall Street Journal in late October? So let me break it down for you. All right, was there an announcement in June 2025 that was separate and apart from the one that was made recently about reduction in force in June 2025? Again, layoffs of 1,200 workers at 4 call centers.
So when we've closed a call center, that information has been publicly provided. I don't remember the specific instance that you're talking about in June. Certainly, it wouldn't be related to, if it were in fact the case, it wouldn't be related to the recent job eliminations. I'd also say that I can't say that those were job eliminations specifically. In some instances, there are relocations of call centers that take place between existing facilities. A call center closes. That doesn't necessarily mean that there's an overall reduction of the force. There may be additional positions that are made available at other locations that are not the location that you're speaking of. So I can't tell you specifically. There have been changes in our call center profile over time, and whether or not those netted a reduction in overall workforce or not is not something I can answer today.
Understood. Before I ask for a late filed exhibit, I have one more question. Separately from that announcement in June of 2025, in February 2024, didn't Charter permanently close 3 call centers, one in Milwaukee, Wisconsin, one in Syracuse, New York, and Cincinnati, Ohio, reportedly laying off 650 workers? Do you have any information on that, sir?
I remember the closure of those call centers, so I'm not disputing that they occurred. Again, I can't tell you whether those closures resulted in a net reduction or elimination of positions. I just don't know because
The
again, we have-
report to the FCC, I don't mean to interrupt you, but
Yeah.
I don't want to.
Yeah.
The report to the FCC was that there were 650, nearly quote unquote, 650 workers that lost their jobs as a result of those closures. So
anything we reported to the FCC would be accurate. Again, it's maybe a matter of nomenclature. I can't tell you for certain. And maybe Greta, you can if you have other information. Happy for you to provide it. But whether those were in fact all job position eliminations, or if they were associated in certain instances with opportunities that would have been presented at other locations within the footprint of our call center environment. I do know that in many instances in which we closed call centers, we notified employees that there were opportunities that were available at other call centers. And so as a result of that, I would believe that not all of them were a net elimination of positions, because again, there was a reference to the availability of other jobs at other locations. And so I don't know if it's a matter of the terms you're using, but I don't dispute that those call centers were closed.
okay, yeah, it's just You know what the average salary or hourly rate of compensation a call center employee receives from Charter?
I'd have checked on relevance grounds, both globally and on a micro basis. Mr. Falk has indicated that the call center employees that were affected per the reference that Mr. Cohen has made were not in Connecticut.
Yeah, I'd be curious as to the relevance of that myself, and obviously it's going to differ greatly based on what part of the country the call center employees are based.
I also can tell you that in 2020, I believe, we instituted for our most entry-level positions a $20 minimum wage. Although we don't have any call centers here in Connecticut, I think that's almost $3.50 higher than the current minimum wage in the state. So, we've been committed to making sure that our employees are well compensated for their positions. And we took a position during the early stages of the pandemic to ensure that all of our employees were at least going to be able to receive a $20 minimum wage.
Okay, I want to answer Your Honor's question. The relevance in my mind is again, not to get in a debate about call center closings. Those are obviously business decisions. But to make a statement that a call center employee making $20 an hour in Wisconsin is going to want to take another job, another position in Southwestern Connecticut call center is.
But I think
that's-
that requires us to read people's minds, and I'm not quite sure we're equipped to do that. So I appreciate your concern. I also appreciate, yes, Connecticut minimum wage will go up to $16.35 in January, so $20 an hour is quite a bit more than that. So if you would like to proceed, Attorney Cohen?
I sure would. Thank you.
Thank you.
Again, I just want to go back a little bit to the call center because I want to follow up on Commissioner Beecher's questions on Wednesday about AI. Is it Verizon yesterday announced 13,000 layoffs, a lot of it being attributed to the use of AI in call centers and customer service. Are any of these reduction in forces, in your knowledge or even opinion, a reflection of Charter's use of AI? I'm not saying it's a good thing or a bad thing. We're trying to understand.
I'm going to object again. I don't understand the relevance.
No, you didn't object to Commissioner Beecher's question about it.
You didn't hear me earlier. I don't object to Commissioner's questions.
So I think the Office of Consumer Counsel certainly deserves a little bit of.
I would sustain the objection. I think for anyone to speculate about how AI is going to affect future employment or not is outside the realm of probably the minds in this room as well as the scope of this hearing. So if you could proceed.
I would like to rephrase the question if you.
Well, I will allow you to rephrase the question and we'll see what we do with it.
Okay. Were any of the reduction in forces that we just talked about the result of Charter's intention or use of AI to replace call center representatives?
Charter doesn't have any call centers in the state of Connecticut, so I'm not sure I understand the relevance of your question about whether or not our employee base will be affected in Connecticut as a result of the use of AI in our call center environment.
Thank you. Cox has an operations center in West Warwick, Rhode Island. I'm sure you know that, maybe you even visited it yesterday. It's my understanding that a number of Connecticut residents work at the West Warwick, Rhode Island facility on a full-time or part-time basis. When we get the number of Connecticut residents who work, well, let me start off. Is it the intent for the post-merger that customer service operations in West Warwick will remain open?
I didn't in fact visit that location yesterday. Kurt would be better able to tell you what the operations of that facility undertake. I can say, as I've said in other instances, that we haven't gotten to that level of granularity with regard to our post transaction functions, and so I couldn't answer the question specifically.
I understand that. Well, Mr. Stamp, I'll ask you, is it your understanding that there are Connecticut residents who work in the West Warwick, Rhode Island facility?
Allow me just a second.
I did.
So I cannot give you specific numbers, but I think it's fair to say that there are people whose work location is Rhode Island who have a Connecticut address. But also, as you can probably appreciate, we have a regional operation. So there may be people who are based in Connecticut who do some work on Rhode Island occasionally and vice versa.
That's my recollection, but yes, thank you. Okay. I'm pretty near the end. Pura 22 charter states that it is establishing a $50 million foundation that will be in effect under the new charter. Can you give us, well, I'll ask a specific question. How much of that contribution, I'll let you find it. I'm sorry, Mr. Falk. You have it?
Yeah.
Okay. How much of that contribution, wherever it's coming from, will be available for Connecticut to address digital literacy, digital adoption, and affordability, particularly in the merged company service area, and particularly in the 4 distressed communities, the distressed municipalities, of which there will be 4 in your combined service areas?
I mean, obviously, I don't have that information today. The foundation hasn't even been established yet, let alone being able to, know how it might consider the distribution of its funds. What I can tell you today, and I think it's fairly evident to you, and it's largely contained in our response to Pura 22. Charter has in the past been I think very generous in its contributions to the communities that we serve today in Connecticut, um, including not just the ones within our service area, but the broader footprint that includes the location of our corporate headquarters. I think Cox, not to speak for them, but I think they've been generous as well in their distribution of funds in Connecticut and beyond, which is a reflection of the philosophies of both companies with regard to being good corporate citizens and participating in philanthropic endeavors in the communities that we serve. In the interest of brevity, I will just refer you again to 22, but I talked extensively in my opening and in the response to that question about things like our Spectrum Community Investment Loan Fund, in which we recently made $1 million contribution to Grow America, which is a community-based financial institution that makes loans to small businesses in Stamford and nearby communities. We've established the Tech Hub, and although that is not specifically related to your question of digital equity, inclusion, and affordability, I think it is illustrative of the types of commitments that Charter makes. We have a Spectrum digital education program that makes grants to entities to help in digital inclusion programs. We've been involved in a number of not-for-profit organizations around the state. Our Spectrum Community Center Assist program, which helps to revitalize community centers, invest in job training, which is also associated with helping to lift people up, made a $250,000 contribution to the Community Action Agency of Western Connecticut. And I could go on, but there's quite a bit of information available within our responses that identifies the types of community commitments that we've made.
Well, thank you. And certainly, and hopefully without an objection from Attorney Bogan, I'd like to say our Office of Consumer Counsel, including within it, our Office of State Broadband, welcomes discussions with you post-merger about where we've learned some of the needs are in your service areas. And we'd love to partner with you and work with you and provide you at least our thoughts about that, if you're open to that.
Of course, be very appropriate to do that. And I think helping to ensure that Charter is a stronger competitor in the state and a stronger company overall will contribute to our abilities to have the resources in order to do that effectively.
And I will jump in here and wearing another hat as someone who used to run a nonprofit. I welcome the addition of a new foundation to Connecticut that will have funds to supply not only for the interests of bridging the digital divide, but also the other very needy and worthy causes in the state of Connecticut. So that's my editorial comment for this moment, and you may proceed, Attorney Cohen, and thank you for your comment, Mr.
I'd like just 30 seconds. Further questions? Thank you. Patience with us. We look forward to home.
Thank you. Thank you, Office of Consumer Counsel. Does the Attorney General have further questions? I think we will take those questions now, and when we get to an obvious stopping point, we will break for lunch.
minutes would need to be done.
Good morning. All right. So I'd like to resume with some privacy questions with some cybersecurity overlap. I understand not all of the cybersecurity individuals here might be able to answer questions, so I'm happy to move those to late files if needed, just as a precursor to everything. In the hearings on Wednesday, I requested late filed Exhibit 4 with the details of cybersecurity plans or standards specific to risk management. I would like to request that information for Cox as well as CEI in a late filed exhibit.
So this is information that may be reliably released with regard to cybersecurity response plans for Cox?
Yes, with Cox as well as CEI as it relates to their risk management, styled in the same style as late exhibit 4. Late filed exhibit 4.
And just refresh my memory, is that was a request for a narrative discussion and not specifically for the plans themselves?
It was the
Details.
details.
Okay. Yep. Thank you.
Thank you.
Sorry, one more clarification. I believe it was stipulated that those details would be subject to an existing protective order. Is that correct? And I guess I believe it would be protected confidential information due to the sensitive nature of it. And so can we stipulate that it is subject to an existing protective order? I can look into that and get back to you.
Yeah, if I may, I think what I recall the request being is kind of a subset of the emergency plan that the companies file every 2 years, and that per statute is confidential.
Mhm.
So it was certainly our expectation that we'll be filing whatever we're filing, subject to confidential treatment.
That makes sense to me.
All right, thank you.
Now, can you please pull up AG7, the publicly filed version? And please let me know when you're there so I don't jump ahead.
Yes.
Now, you indicated in your responses to AG7, harmonizing incident response capabilities is a day one focus for the companies. What are your other day one issues?
Could you be more specific? I mean, obviously, we'd have a lot of day one focuses in a variety of different elements of our business, and they would vary, I'm sure, depending on the availability of information, the sensitivity of information, the ability to finalize integration, for example. And so other day one focuses could be numerous. I don't know what each element of any individual piece of the business's activities would be. This was intended to demonstrate that cybersecurity and ensuring the protection of our customers and their information was critical to our operation. But I can't tell you other day one focuses that the company would have. I'm sure that there would be others.
Would it be helpful if I requested that in a late filed exhibit?
Well, I don't know how helpful it'll be. I think what Mr. Falk has indicated is that it could be varied, it could be numerous depending upon the business unit. So if you could maybe give better sense so that we can kind of drill down? Because otherwise we could be looking at numerous business units across the country, et cetera. And that would be voluminous and overly burdensome.
Is this, Attorney Cormack, specifically is related to cybersecurity and/or privacy protection?
Yes, and I apologize that I did
Oh.
not make that clear.
Yeah, I'm sorry, I didn't understand that to be the questions. but-
Apologize.
I apologize. Uh, I think that there were other day one focuses that were outlined in our discovery responses. I don't think that this was the only element of our responses that talked about day one focuses. Certainly any of the others that were identified in those responses, and I don't recall every instance in which we referred to something being a day one focus. But I would assume that there are others. If you give me a second, I can just confer with our counsel on that and see if there's anything else that I should bring to your attention.
That's great. Thank you.
I think generally understanding aspects related to data is going to be an initial focus day one priority. If there are specific elements beyond what are referenced in the response, we can provide that as a late filed exhibit.
That would be great. Thank you.
Yeah.
Any additional information not previously supplied with regard to day one responses for cybersecurity and privacy protection?
Exactly. Thank you.
That will be late filed exhibit 21.
Now, I understand from the hearing on Wednesday that you are in the early stages of the integration planning. Can you please provide a late filed exhibit of the plan of your plan that you anticipate creating as it comes to integration of cybersecurity and privacy?
Yes, we provide a late file exhibit. Assume you're asking for us as opposed to Cox, or you're asking for us on a combined basis to offer that? I just want to make sure I understand specifically, clearly your question.
Thank you for clarifying. Would the companies be able to respond combined, or would it be best to keep those cordoned off and separate with two separate late files?
I mean, I would, to the extent you're talking about post-integration activities, those are better responded to by Mr. Falk.
And can you restate your request, please,
Yes.
Attorney McCormick?
Yes. A late filed exhibit outlining the plan of the integration planning as it relates to cybersecurity and privacy issues.
So you're saying what is our plan pre-closing for how we will, for the plan that we will develop post-closing?
Exactly. Yes. A bit of a timeline as well as some of the details as to when you anticipating reaching certain milestones.
Okay, thank you.
Thank you. Now, Mr. Falk, when you were discussing one of the read-ins, you had made reference to maintaining a web page to privacy rights to consumers and non-consumers alike. And there were two web pages referenced, that one as well as privacy preferences web page. Now, I don't recall seeing this as a part of the record in this case. If it is, would you be able to provide a read-in to let me know if I've missed it along the way? But I'm pretty sure it's not. So if it's not, could I get a late filed exhibit with that information?
You're asking for the location that non-customers can go to obtain information about their privacy rights?
So you referenced 2 web pages in the read-in. Would you be able to provide those 2 web pages as with that information?
Sure, yes. You believe that they're not covered in response to OCC 115, where we identify where these policies are available,
Let me-
correct?
I don't recall seeing it. I could be
No,
mistaken.
you might be right.
Because I don't,
I don't know that you, yeah, I don't know that you need to be a charter customer to access the website that was provided, which is the spectrum.com policies, your rights, your privacy rights. And again, from that portal, you can access other information about our privacy policies to the extent that it's not covered there or it needs to be clarified. We're obviously happy to provide you with that information.
great, thank you.
So request on information where non-customers can obtain information about their privacy rights from Spectrum Stroke Charter?
Ensuring that the read-in information is a part of the record. I believe if it's already provided as the link, we already have it as a part of the record. So I don't believe we need to ask for it as a late filed, and especially with
okay.
so I apologize for
All
that.
right, okay, that's fine. Just
Thank
want to
you.
make sure I'm
I
clear.
appreciate it. Thank you.
Yeah, I do think you have it as a link, but I'm not trying to
No, not at all.
be obstructionist. If there's something that you don't have related to the question that you're asking, we'd be happy to provide it.
Excellent. When we break for lunch, would I be able to double check that and then ask for that as a late filed or,
I think we could arrange that.
thank you. Just not to waste any more of the commission's time. Or the authority, rather.
Attorney McCormick, do you know approximately how much more time you'll require?
Um,
I'm not trying to rush you. I'm just trying to find an obvious, if you're, if you've got another half an hour or so, we'll power through.
yeah, I have more than a half hour to power through. I have some more.
Oh, all right. Well, we'll assess in about half an hour and then I'll make a ruling on lunch. Thank you.
And please stop me if I need to be stopped before that half hour. Now, there was a question or 2 earlier in the hearing on AI on Wednesday, as well as some questions about AI today. Does Charter currently use chatbot?
Yes.
Now,
But, and if you'd like, I mean, that was a yes or no question. If you'd like more information about our chatbot services, Greta is here and can answer in more detail. But yes, we have a virtual assist that's available on our website.
Ms. Kim, would you be able to provide more information about your chatbot?
Yes, as Adam alluded, we do have an interactive virtual assistant, which is a chatbot, which our customers can interact with to pose questions and to get answers that are readily available, as well as to complete specific actions that they may want to do, such as make a payment or ask for the nearest store. At the same time as the availability of the chatbot, we do have, as part of our 100% US-based in-house customer service group live agents available through chat 24/7, 365 days a year that the chatbot will, that customers can request to speak to if the chatbot is unable to resolve their issue.
Now, can customers ask to immediately be placed to a customer service representative, or do they have to run through a series of questions with the chatbot prior?
We do request that the customer provides identifying information to the extent that they can, as well as a high-level indication of what the issue they're looking to resolve is regarding, so that we're able to get them to the correct agent that will be able to most expediently resolve their issue. But even in the absence of that information, customers can request to speak to a live agent.
Okay. Now, is chatbot in-house or outsourced?
Sorry if I'm.
Of course.
Yes.
Are you asking when they go to a live agent, or are you asking something different than that?
Prior to that, with the actual chatbot itself, is that function in-house or outsourced?
I'm sorry, I missed the clarification.
So the chatbot itself, prior to getting to a live agent, is that a function that's in-house or outsourced?
Well, so we do use an external platform upon which the software is based, but in terms of the governance of the interactions and how the chatbot interacts with customers, that is managed internally.
Now, with the with chatbot, does chatbot use a series of canned questions, or is chatbot generative?
So it is an interactive virtual agent. So depending on the nature of the response from the customer, it does provide various customized responses.
But are those from a list of pre-provided responses, or are they not just from the list? Or is there no list, is my question.
If I may have a moment, I think. In terms of the specifics of the various paths and how they're provided, if we can take that back, I want to make sure we provide you with the correct answer.
Thank you. And before asking for a late file on that, I might continue down my line of questions in case that needs to be expanded to include some more chatbot questions. If that's okay with the authority. Thank you. Now, what data of the customers does the AI have access to? The AI chatbot have access to?
I'm sorry, if I may ask for clarification on the question you asked, what access does Charter have access to through the chat interactions?
What does the chat bot have access to in terms of customer? When it provides responses, does it have access to personal information, sensitive information? What information does the chatbot have access to view?
So it is a platform that is linked to various internal Charter systems so that we can correctly assist the customer. So as part of the flows, for example, a customer would identify themselves in order for us to be able to assist them with the specifics of their account.
But of course, it wouldn't include information that's been the subject to an opt-out consent request of a customer. So if a customer asked that data associated with themselves, personally identifiable information, not be utilized, then that information would not be included. And essentially, I mean, I think following the privacy requirements under Connecticut law, including the opt-in for sensitive information. So there may be other elements outside of that, but someone who has not opted in for the inclusion of sensitive information, or not opted out for the exclusion of non-sensitive information, obviously that wouldn't be included in the chatbot's information, in accordance with the law.
Now, does Charter make any of that data that is used in those chatbot interactions, or is that available for sale?
All information that would be, that is part of the domain of chat would be subject to our privacy policy rules and our obligations.
Now, just to clarify, within those privacy policies and rules and obligations, is that data available for sale that's collected with the chatbot?
If I may have a moment.
Of course.
So I think pursuant to our privacy policy, the specifics of chatbot interactions would not be subject to sale, but generally we abide by our privacy policy rules and obligations.
Okay, thank you. Now, is that data used in those chatbot interactions? Can that data be scraped to create or to inform a large language model?
May I ask for additional clarification on what you mean by scraped for a large language model?
Sure, and those are the terms of the taking of the data, making sure, my goal here is to make sure that the data is going to be safe, and to know what happens to this data. So where does this data go after engaging with the chat box? Does it potentially go to large language models? Does it not? If that helps provide context.
If I may, Ms. Kim is able to answer certain questions. Unfortunately, the person who was better able to answer these questions was Mr. Tem when he was here. I'm not trying to avoid giving you the information that you're looking for, but it is probably better reserved or provided in the form of a late file exhibit.
Okay, thank you. And I know there's some overlap. I tried to do the customer service chatbot engaging with that customer
So
service.
the specifics of this is, can the data from the chatbot conversations be scraped and put in a large language model?
Yes.
Okay. That would be late file exhibit 23.
Now I'd like to turn to Cox for that same line of questions. Does Cox currently use chatbot?
Yes, we do.
Is Cox's chatbot in-house or outsourced?
That I do not know. Happy to provide it, and knowing what's ahead of me, most of mine will end up in the late filed bucket as well.
In the late file bucket as well. Okay.
Do you want to have just one ginormous late file exhibit on this cybersecurity issue?
That would be very helpful if possible, and if,
Well, I don't want to make it more difficult for Cox and their attorney, but
I want to make it,
yeah.
I don't want to make this request more burdensome or more burdensome to shift through. So if I can ask counsel, what would be the best way to provide this information? Whether it be in one big late filed exhibit, whether it be in two with charter and Cox is separate, or what makes sense here?
I think Cox's should be a separate late file.
I would have it as a separate late file, but the question is,
Yeah.
do you want all questions relating to the chatbot and its relevance to cybersecurity and privacy to be in one late filed exhibit or in several?
I think it can be in one.
Maybe, yeah, we'll just do kind of one narrative that kind of walks through. If I
The two or
understand,
three separate issues in that one.
with, yeah, the overarching question being use of AI chatbot and its implications related to customer data and privacy.
Yes.
If I could add, if it makes any sense, also note, don't want a big essay here, but note any applicable federal or state, legislation policy that might also be applicable to the protection of customer data. In other words, by other jurisdictional entities. Thank you.
May I just have one moment? So in discussing with my client, I think it makes sense to walk through some of these issues with the witness, so we understand which questions are specifically intended to be included in the late file, and drill down into what can and cannot be provided now. And then, I think particularly to your last to your question, that is likely a very long essay because of the amount of pending legislation at the federal level and state by state as well. And so I think just understanding specifically what we would like, what we need to touch on, I think would be very helpful to just understand a little better.
And just to note, excuse me, but I that's a reasonable thing to say, that this is evolving area of public policy. And so just, your sense of compliance with existing policy, but not trying to anticipate everything that's going to be evolving in this area. That's I perfectly understand what you're saying there. Sorry, Mr. Bogan.
Yes, I just want to make sure that we give you what you're looking for. When you ask for state or federal policies that might be affected here, you're talking about those pertaining to AI in as much as it relates to cybersecurity plans.
Yeah, narrowly, yes, protection of customer data in this area, because I'm educating myself partly. So to the extent that there's something already applicable that, where you're aware of compliance issue or the need to comply, just.
All right. So if Attorney McCormick, you would like to go through specifically the areas that Cox should address in terms of this late filed exhibit, so we make sure that everybody has the relevant information. Thank you.
Thank you.
And the use of AI and chatbots and all that other good stuff. Thank you.
Thank you. Now for Cox, so is the AI chatbot in-house or outsourced?
Yes, I do not know.
I don't know. Oh, yes. I apologize. I asked that.
No, that's fine.
Now, do you know if AI chatbot is used a canned series of questions or if it is generative?
And we'll add that to the exhibit.
Excellent. Thank you.
Sorry, I'm just trying to keep track with my writing, so just give me one moment to catch up.
Of course.
Sorry, the one you just asked was, can you just repeat it?
Yes. Does it use I said canned, but does it use a pre-selected area of questions? Are there a number of questions that can be selected, or is this generative?
Okay, thank you. You may proceed.
Thank you. What data of the customers does the AI have access to?
We'll add that to the list, please.
Thank you. Attorney Bester, can I
Yes,
move on to that?
please
Good,
proceed.
got
Yep,
it.
sorry.
I want to make sure I'm not
Okay.
cutting you off too early. Does the company make that data of the customers available for sale?
I'm gonna have to get back to you on that one.
Thank you.
You may proceed.
Thank you. Will the data in this AI chatbot be scraped to build or to help inform a large language model?
Add that to the list.
Thank you.
Trying to spare Mr. Bester's hand, but
Okay, you may proceed.
And is chatbot being used to generate revenue for the company directly or indirectly?
I do not know. And just to clarify, I'm assuming as it relates to the extent we use chatbot for customer service, to continue with this line of questioning, is there any AI anywhere at Cox that's making money somewhere?
It's related to chatbot and that interaction that customers have with AI in that realm.
Thank you.
Have you come to the end of your questioning with regard to AI and chatbot?
Yes.
In which case, this might be a good point to break for lunch. I know you have further questions.
Thank you.
If that would suit everyone, we will recess for lunch at 12:10 and reconvene in 45 minutes. I think 12:55. 1 o'clock? All right, I'll give you an extra 5 minutes. So you can do your homework on chatbots.
5 minutes late for my plane, that's on you, Bogan.
You got it.
Commissioner, is ginormous a legal term or is that a policy?
Absolutely.
Right, thank you.
Yes, we don't want you passing out, Mr. Falk. All right. Well, I think we have the required individuals in the room. We will reconvene this evidentiary hearing day 2, and I believe Attorney McCormick has some further questions.
Yes, thank you.
If I may, Commissioner, I had asked Attorney McCormick if she had any more AI-related questions. I think, and I don't know if she was going to check to see if she did.
Yeah, I have a few more, but it shouldn't be too much left of my cross.
Okay.
Yes.
Because I think that part of the struggle of the company is having, not to suggest that Mr. Fox struggled, we comply with the law. The problem is there aren't a lot of laws. And so I understand why she's asking the questions, but, we'll see where she goes.
I will bear that in mind as we proceed, and I'm sure Attorney McCormick will as well. Thank you, Attorney Bogan.
Thank you.
Thank you. Now, Mr. Stamp, you made reference to some other AI uses that your company can use as it relates to the sale of data. What are those other AI uses to the sale of data?
I'm sorry, if I inferred that all of our other AI uses separate from the chatbot are related to the sale of data, that, to the best of my knowledge, is not incorrect. I know we have other uses of AI within, like, our network monitoring, our network telemetry that we use internally to monitor the health of our network and deliver services. I am not aware of any, and happy to have it as part of the late filed exhibit. To the extent relevant, any other AI uses that generate revenue for the company, or however you want to phrase the question. I'm not sure, other than, related to the use of customer data. I'm not sure. Again, I'm not going to be a lawyer, so I'm not going to say I'm not sure of the relevance, but
So,
happy to.
Attorney McCormick, just to clarify, would this be regard to any uses of AI that would affect customer data that might be subject to sale down the road?
Yes, and I apologize that I wasn't precise in identifying specific.
That's fine. I just want to make sure we're on the same page when we get you the information you're looking for without driving the people back in Atlanta nuts when I ask a super broad question.
So data generated by the use of AI that would be commercially for sale?
Yes.
If there is any, or not?
Yes.
Are we including this in late filed exhibit 24?
Yes, we could do that.
All right.
And Mr. Falk, I assume that information isn't readily available for charter. So could I also add that to the late filed exhibit for charter?
I don't think it's relevant to the inquiry. I'm having trouble understanding the relevancy of what we do with data outside of what we're required to do. So if there is an opt-out of sale of information under the relevant requirements in Connecticut, then obviously we don't use the data of those people who have requested to have themselves opted out of the sale. Other uses of our data or of data we obtain outside of what is required to comply with the law, I don't think is relevant. So I don't believe that we would provide that information.
I'll go with Mr. Fox's objection.
I can.
So
I apologize.
So are you restricting this solely to AI data that would affect privacy that may be offered for sale?
Yes.
I think the fact that you comply with all the privacy laws would also relate to any data that was generated by AI. Am I inferring incorrectly?
Correct. Yeah. I mean, the data is data we collect from the consumer, and AI used to generate a lot of different things from a lot of different data sources, of which I don't know what they are, But as it relates to consumer data, we follow the Connecticut privacy laws in terms of
So
what's
basically,
required for opt-out or opt-in purposes.
all data that might be generated anyway, whether by AI or through traditional methods that bore any relevance to consumer privacy would be subject to the same laws, no matter where you got the data, no matter where it was generated. If it was subject to Connecticut consumers' privacy laws, you would abide by those.
If it's personal data under the
Is
definitions.
that
associated with
sufficient?
Connecticut
That
law.
is sufficient. Yes,
Right.
I can move on.
And forgive me if I was a little bit vague. That's what I was trying to convey at the outset. You know, we comply with whatever the relevant state laws are, whether they're AI related or otherwise, in as much as it pertains to customer data.
All right. Okay, thank you.
Thank you.
Does the, I think our witness just indicated that it is the same here under Cox, and so I was just wondering, is the questioner satisfied, or is there still a need to provide additional information under LFE 24?
No need to provide the additional information. I'm satisfied with it. Thank you. Now, referencing OCC 30, and I'll give you a minute to flip to that page.
Okay.
Now, I understand the notifications of rate changes are undocketed correspondence filed with the Pure. And there was a note that Charter has no objection to the requested materials being made part of the record. I'd like to request that the documents from 2023 and 2024 be made part of the record in a late filed exhibit, please.
As indicated in the response, we have no objection.
Thank you.
I'm just, can we clarify though? Because there's, you're saying the information that was in the undocketed correspondence from 2023 and 2024. So in this response, it says April 14th, 2023 versus through a number of entries through December 17th, 2024. You want us to provide different information or?
Provide those in this docket as a late filed exhibit. So we have it to reference in the docket.
Just by way of clarification, the response indicated the dates upon which we've made the filings, and we said we had no objection to them being made part of the record, but no one had necessarily asked that they be made part of the record. So she's asking if the 2023 and 2024 reports be formally made part of this record. Am I correct?
Yes.
No, I don't have an objection.
Okay. Thank you.
And that's with regard to a particular OCC,
Yes.
30.
OCC 30.
OCC 30. Yes, that's late filed exhibit 25.
Now, can I ask you to turn to OCC 133, please? To save us a little time, can you turn to page 1 of Exhibit A on the first half of the page? And please let me know when you're there.
Are they paginated?
So it should be, if you're looking at the PDF file, it should be page 6 of 54. with all of the various responses filed with OCC 133. But if you're looking separately at each of.
You're asking me about the long exhibit that's attached to the response to this question in Exhibit OCC 133A.
Yes,
Okay, and then there are several that it goes on for many, many pages. Is there a specific page within that that you'd like me to?
the first page.
Got it. The one that says new savings?
Yes, exactly.
All right, yes.
I'm sorry, Attorney McCormick, we're looking at OCC 133, is that correct?
OCC 133A. And then the first page of A.
I'm with you.
Thank you.
Oh, I see.
Now, do you see on the bottom second half of the page where it says no added taxes or fees, no surprises on your bill? On the left side of the page.
Yes. Correct. Yes, I see that.
Thank you. Now, I ask that you turn to the smaller print underneath the spectrum. Now, do you see where the fine print there says taxes and fees extra in select states? And a couple lines down from there, additional charges for installation.
I see where it says taxes and fees extra in select states. And then what's the next thing that you want me to,
The next one down is
the standard rates apply after promo period or if qualifying service not maintained, offer subject to eligibility requirements, additional charge for installation.
yes, additional charge for installation.
Yes.
Yes, thank you. Now, can you explain the text above saying no added taxes or fees and then that fine print that then says taxes and fees extra in select states and additional charges for installation?
Well, I can make some assumptions. I don't know if that's a good idea. And I can certainly follow up with you on it. But broadband services are subject to the Internet Tax Freedom Act. There were certain states that were imposed taxes and internet services prior, I think, to the enactment of the Internet Tax Freedom Act. And again, I don't do taxes for us, but my recollection is that in those instances, there could be a tax associated with an internet service in those states that were under this sort of grandfathering pre-Internet Tax Freedom Act. So I think it's intended to modify the statement in terms of making the statement that taxes or fees may apply in certain jurisdictions.
Now, is Connecticut one of those jurisdictions?
So the selected states where the internet taxes do apply is Texas, which does have an effective tax rate on internet, as well as in California, where there is a cost recovery charge related to wildfires that was part of California state. And those are the only two locations where the selected taxes apply.
Thank you. Now, when this ad says no added taxes or fees, what's your understanding of how fees is defined? And to give a bit of context to my question, do you mean that government imposed fees how do you define? Is that included in the definition? Is it not included in the definition? All in fees versus separate fees?
Can you repeat the question, please, Attorney McCormick?
How do you define fees as it appears in the ad?
Yeah, I'm going to have to object because I think that these witnesses are not going to be able to answer that question because it really calls for a legal conclusion.
Yes, although I can say that in this instance, right, fees relates to the fees that that Greta is talking about, right? So fees would be those imposed for something like the cost recovery that she mentioned. This ad relates to internet services, and there aren't a whole lot of fees that apply to internet service. It becomes more complicated when you have the discussion related to voice services or cable television services, right? For example, in certain places, we have a fee associated with paying a franchise amount to the local jurisdictions, a franchise fee. Or in certain instances, we have a fee that's imposed, for example, in Connecticut on PEG access and capital costs associated with PEG access. Those fees don't relate to our internet services, only to our cable television and services. And then there are certain fees that we described earlier that relate to voice services, telecommunication services. So I don't know if that answers your question, but give some context to, I think, what you're asking.
Thank you. Now I'd like to request you turn to OCC 87.
CC 87?
And please let me know when you're there, because then I can direct you where specifically in OCC.
I'm there, yeah.
Can you please go into provide a copy of the bill for the following type of account, letter G, business cable only, the second page of that exhibit?
That's exhibit OCC 87F
G,
or G?
as in George.
G.
Excellent. Are you on the exhibit?
Yes.
Can you please turn to the second page of that exhibit?
Okay.
Great. Now, please go partway down the page, about halfway down the page to the tax and fees section.
Okay.
Now, do you see in that second sentence where it says these taxes and fees may change without notice?
Yes.
Can you please elaborate on this? What taxes and fees can change without notice?
Well, so you're,
And I'm happy to take it in a late filed if it's more appropriate to ask for it in a late filed exhibit.
I think I can provide some context for it, and if you need additional information, happy to provide it as a late file. Certain of the fees and taxes that we pay fluctuate by year based on either requirements of the regulatory agencies or they fluctuate based upon the gross revenue derived from the service that is received by the consumer, right? So if a customer is receiving cable television service for $100 a month, that's different than the tax that would be applicable to a cable television customer who is paying $80 a month or $60 or whatever. And so it's intended to reflect the fluctuation that exists as a result of those changes, right? The FCC regulatory fee that we discussed earlier was one that was set by order of the FCC each year, and that amount could vary by year. And so it was intended to reflect the fact that changes in those taxes and fees may occur on your bill, particularly, where they're itemized. And so that's what that reference is to, those fluctuations that may occur as a result in the change in the tax rate or the change in the applicable amount of the fee that is imposed on us from a regulatory agency, et cetera.
And I would just add here, Attorney McCormick, that also may be subject to legislative changes which impose a fee that was not earlier assessed, as I think we recently saw with the firefighters cancer fund, and there's an additional tax fee on people's bills. So I think that might be part of the equation as well.
That makes sense. Thank you.
Thank you.
As of January 1st, I think, right? Yeah. Yeah.
So for those fees that you do know are subject to change year over year or month over month that have the possibility to change, could you please provide a late filed exhibit identifying those fees that tend to change? I understand there are some legislative ones that you wouldn't be able to predict, but the ones that you have an understanding tend to fluctuate.
We certainly can. I might be able to address that in looking at the response to, I forget what pure question number it is. So if you give me a moment, I can take a look at that.
Thank you.
We'll provide it as a late filed exhibit if you wish.
So this would be late filed exhibit 26 and a list of fees subject to change?
Yes. And can I
They're all
also-
subject to change.
Subject to change without notice, quote unquote, on customer bills.
Yes. Thank you.
Pull that up. Can I just ask, is there something in, I had taken the exhibit out, so I couldn't find it at the time. That's why I said that. But is there anything in our response in OCC 86 that makes that unclear. I mean, I can go through each one of the fees if you wish. But I believe it's fairly self-explanatory. Is there a particular one there that you're unclear about? I mean, for example, the 911 fee in the state is a flat amount. So I would imagine that doesn't change. The Federal Communications Commission regulatory fee, as we mentioned before, is set by order. So that one does change, et cetera. Are there ones specifically enumerated that you're unsure about whether or not they are a tax or fee that might fluctuate?
Thank you for asking. So that actually brings me down a line of other questions. Let me flip ahead to that.
Just so the record's clear and I'm clear, are we holding off on the late file for the time being?
Holding off on the late file. That's probably a good idea, and then I think we can revisit
Thank you.
when I finish this line. Thank you, Attorney Bogan. I think that'll be clear for the record. Now, referencing OCC 86, the request from OCC requests fees, surcharges, and taxes charged. But I wanted to see, are all-in fees, surcharges, and taxes included in this list that you've provided?
And just clarification, you said all in fees, taxes, and surcharges?
I'm just looking to clarify to see if the all-in fees, taxes, and surcharges have been provided as a part of this response. And I can lay some foundation too to get, if that would be useful.
If the witness understands
Yes.
what you're referring to, you can answer.
I mean, we're not required to itemize them and collect them from consumers on the bill if we so choose not to, right? We can remit a fee or tax ourselves as long as we meet the obligation of the taxing authority. And so I don't know whether or not in the instance of our all-in pricing plans, whether each and every tax that we pay is included in the cost of that service. I think what we're saying in that instance is that the price you see is the price you get, and we are going to charge you that price. And what we are required to remit to any taxing or fee authorities is our obligation.
Thank you. Just one moment. Now, is it your understanding that you charge a broadcast fee or a retransmission fee as part of your all-in pricing?
We don't have all-in pricing. The all-in pricing plans that we have relate to our mobile service and our voice service. So we advertise that all-in pricing related to those two particular services. Programming fees associated with broadcast retransmission are on our cable television bills. And And so I don't fully understand your question because it doesn't relate to, we don't have all-in pricing for our cable television services. We're required to disclose as a result of, I think, some recent actions at the FCC, the entirety of the charge in our advertising and marketing of our services. And we now disclose that information in that way.
That makes sense. Thank you. Now, I don't see the broadcast surcharge or a retransmission fee listed as one of the requests or as one of the fees, surcharges, and taxes charged by charter in response to OCC 86. Am I correct in, I'm not missing it here. It's not referred to by a separate name. Is that right?
Right, that's right. It's not a fee that we remit to an authority. I think that these all relate to fees that we remit to an authority in response to a tax obligation that we have. So franchise fees, for example, which is a fee that we're, well, I guess the gross revenue, gross receipts tax is included. So yeah, no, it's not.
So I don't see as a part of the question of OCC 86, excuse me, that it asks for fees, surcharges, and taxes remitted to an authority. Is there somewhere in there that I'm missing that?
Excuse me?
I'm not seeing the that the question asks for fees, surcharges, and taxes charged by charter that are remitted to an authority. But correct me if I'm wrong. Is it in there that it's just fees, taxes, and surcharge remitted to an authority?
Yes, these are. Yes, we obviously interpreted the question perhaps differently than you're interpreting it now. And so we included in our response fees, taxes, and surcharges that are remitted to authorities, yes.
Okay. Now, I'd like to request a late file that includes the taxes, fees, and surcharges, not just remitted to the authority, but that charter charges, both that are included as separate line items on the bill and also those that are not broken out on bills.
So all taxes, fees, and surcharges, irrespective of where they are intended to go? What?
Yes.
Okay.
So
In Connecticut.
In Connecticut, yes. And similar to the way OCC 86 is fashioned, I would also like explaining why each fee is calculated, as well as the stated purpose for the basis of charging. And the amount.
I'm sorry,
Yes.
the way in which it's calculated
Yes.
is contained in the response to the prior question that I answered. So
My understanding is that wouldn't apply, and I don't have it in front of me, to those non-governmental fees and taxes.
Yes.
So this is for the non-governmental fees and taxes, for example, your broadband fee or the franchise fee. Am I putting words in
those
your
are-
mouth?
the franchise fees are fees that are remitted to authorities. I mean, if you're asking about the broadcast surcharge, that no longer exists as a separate surcharge on consumers' bills after the FCC rules were implemented. So I don't know if that's specifically what you're asking, or if you're asking something else. But yeah, so is that what you're asking?
So I understand it's now not broken out.
Right.
It still exists, and I would like to have that listed as the fee, surcharge, and tax.
Ms. McCormick?
Yes.
If I may, information regarding the broadcast retransmission surcharge is provided in OCC 99.
Thank you. Just one moment. So Attorney Bogan, yes, there's information about the summary of rates, but not how the broadcast surcharge is actually calculated. With information that that was requested in OCC 86, there's more narrative information that I'm interested in, as well as any other. I understand sometimes there are sports fees and other fees. So if there are any other fees that aren't specifically broken out, I'm interested in those as well.
I guess I'm not following you because our rate structures aren't regulated. And so I'm not sure what the relevancy of it is. There was a rule enacted by the FCC that said you can't have a separate surcharge for these services. And as a result of that, the surcharge that we have for it was integrated into the overall pricing of the service. So I'm not following what it is that you're looking for.
I'm looking for those components that are factored into that overall price. And that's a component, that broadcast surcharge still. Even if it's not separately broken out as another item, it's still a component of that larger.
You want to know how much the broadcast surcharge is?
How it's calculated, how much it is, the information that was requested in OCC 86, but as it relates to that broadcast surcharge and on any other surcharges or fees.
But it's not, I don't understand the relevancy of that to this inquiry, as our rates are not regulated by the authority or at any level. So how we calculate the broadcast surcharge is not relevant to this proceeding. I mean, if you want to know what the broadcast surcharge is, happy to tell you what that is. If you want to know the elements of it, again, our rates, it's part of our rate, and those rates are not, again, regulated by the authority. So I think
You've said it all.
Perry Mason, objection.
I think it might help me formulate a decision here if you explain why you feel this is relevant, particularly because it's a bundle. I'm sure that might change depending on what services you're providing. Tell me the reasoning, please.
The reasoning, I'm curious to see how this rate might change throughout the transaction if the rates are different between the two companies, and knowing how much bills could go up for customers. And to understand how it works as a part of this larger component.
If I may, Commissioner, the issue is that, as Mr. Falk said, the rates are not regulated. And if she wants to try to draw some conclusion as to what might happen post-transaction, well, the information in OCC 99 is as illuminating as anything else, because it gives you a 5-year history of what the surcharge has been. So I don't see the relevance.
One would assume there would be equal application of the surcharge post-merger.
So as it relates to the various surcharges, there was a response, and I apologize, I don't have it right in front of me, to one of the OCC broadcast surcharges that this rate has gone up over the years. It's gone from, I believe it was $3 back in 2014 or 2015 to, and this is all publicly filed, to $22 now. And so that's the way in which that's calculated, I think, is important for us to understand.
If you look at response to Pura 5,
Yes.
you'll see that the rates that we offer for our tiers of cable television service are generally lower than the prices that are offered by Cox for similar services. Again, I'm not going to pretend to say that I've compared every programming network available in our tiers versus every programming network in their tiers. But if you look at Pura 5, I'm going to do in a moment. So in response to that question, we offer the rates for our services on an all-in basis that includes whatever applicable elements exist for either of our broadcast surcharges. Spectrum TV Platinum is offered at $165 a month and a promotional rate of $145 versus the Contour TV Ultimate package at $172 a month. Contour TV Preferred is $125 a month, not offered on a promotional basis. Spectrum TV Select Plus is offered at $130 a month, and a similar plan without regional sports networks is offered at $120 per month. On a promotional basis, $110 and $100. So in both of those instances, our standard packages for cable television are less expensive today. They're received from Charter than they are from Cox. The broadcast surcharge is now incorporated as a result of the FCC's actions into the overall price of the product. The overall price of the product isn't regulated at any level. But you can see, if your question is whether there will be an opportunity for consumer benefits associated with the provision of our video services, just comparing the packages, they're less expensive. when you include beyond that, the fact that Charter has negotiated programming agreements with content providers that allow for the free addition of their streaming services associated with those underlying packages. It offers another $125 in savings to consumers who take those packages. And so if your concern is whether or not there'll be more competitive pricing for consumers as a result of the transaction, I think it's apparent from our responses that the answer is yes.
Is that satisfactory, Attorney McCormick, or would you like further detail? Because in my view, that although helpful and users might very well opt for those less expensive packages, it doesn't actually address the question of the elements of that broadcast surcharge and what has driven the increase. Now, obviously, some of that is inflation. So would it be possible to drill more deeply down into that broadcast surcharge and discuss the elements that make it up and why it has increased?
Commissioner, if I may, Commissioner, the issue is, I mean, it's one thing for us to give the numbers, but to go into the pricing methodology and the way that the company calculates it, that's a little bit different inquiry. And that's why I said, if you look at what was provided in, what was it, OC 99 or whichever one it was, you can see what the broadcast surcharge has been over the last 5 years, irrespective of how it's calculated. That's what it's been. And then it gets folded into these rates. So it's almost irrelevant how it was calculated.
But I think it's relevant to look at an explanation of why it may or may not increase. And I think that's, again, I don't want to put words in your mouth, Attorney McCormick, but that is what she's trying to identify. Because obviously, limiting rate shock for consumers is something that this commission is going to look at as we look at the merger because of our need to protect the public interest. So
I understand. I understand that. Maybe this will help clear up some of the concern. Retransmission consent, which is the process by which we negotiate with programmers for the right to their content, is a significant cost for cable operators. The broadcast surcharge includes and is associated with and has gone up significantly in recent years, despite our best efforts to control those costs because of the costs that the content owners, the broadcasters, require us to pay to license their content. Some of that may be associated, with their own profits. Some of that may be associated with, for example, sports programming rights. You've seen how sports programming rights have ballooned over the last several years, and many of the broadcast providers, broadcast television providers, carry sports programming as part of their broadcast services. So these are the fastest rising component associated with programming costs, and they have gone largely in one direction. I don't know that I can tell you for sure where they would go in the future, but the likelihood is that they would continue to escalate in some manner as they have in the past. At Charter, we've tried to address that, and one of the ways we have addressed it is to negotiate these new programming rights that allow our customers to get access to the streaming content of these providers, because many of these providers are investing significantly in their streaming platforms, and we felt that it was unfair for consumers to take an underlying package from us that includes ESPN, for example, and not also get access to ESPN Plus. Same thing with Disney and Paramount and others. So our rates aren't regulated, as I've said in the past, but our objective is to do everything we can to try to contain the escalation of programming costs, because ultimately those costs have to be borne and passed through to consumers.
So just to put a point on this, that the structural change, the merger, you're asserting should help mitigate or provide opportunities to mitigate those costs as they might affect customers going forward.
Certainly help to curtail them, right?
It opens opportunities.
Yeah, I mean, look, we believe that scale helps in that manner. For example, when you're negotiating with anybody, and we talked about this a little bit in the synergies section of our discussion, right, in terms of procurement efficiencies. While I don't negotiate programming contracts, I would assume that some of those benefits of scale could also come as we sit across the table from programmers in the negotiation of those contracts. I also think that the ability to extend the things that we have been able to uniquely do as Charter today into the Cox markets will provide benefits to consumers in these areas that will offer value. And some of that is the streaming deals that we have reached to include them as for free of charge as an addition to the underlying package. Another is our ability. We've been very successful in renegotiating agreements with regional sports networks. There was a time that regional sports networks wouldn't allow you to carry them unless you carried them in your most widely viewed tier. And of course, there were some people, who love the Celtics or love the Knicks, and there was other people who couldn't care less about it. And so we've been able to renegotiate our agreements with regional sports carriers that has allowed us to discount one of our most sort of widely purchased service tier, and we offer it for $10 less. So we have Spectrum Signature Plus, a Spectrum Select Plus, which includes regional sports networks, and a Spectrum Select Signature, which doesn't. And we offer that service for people who aren't interested in sports programming, regional sports programming, for $10 less. So we've been trying to do things to innovate in this area in order to make the cable television package more attractive, because we want to not just retain our existing customers, many of who have gone to streaming alternatives, but we want to also be able to grow our video services in the future. The last thing I would say is, for those who just simply choose no longer to have a cable television package, it's important for you to know that we also have launched a digital app service on our television platform that allows customers to manage those apps in a efficient way for them, and order those apps if that is what they choose. So while we're trying to compete against these folks in the delivery of video services, we're also meeting customers where they are and creating platforms and opportunities for them to get the content that they want from whomever they want.
Okay. And so do you believe your national competitors have been able to capture those scale advantages that you would like to capture? I know that's a very general, I mean that just generally. I
You mean, when you
another-
say do you mean like Netflix or?
No, I'm thinking other providers, that they, service providers that they, AT&T or whatever, that they have been able to, that have.
No, I think many of them have largely walked away from it. Right.
Right.
That's something that we haven't done, right? If you look at many of the incumbent local exchange carriers who are upgrading their facilities to offer higher bandwidth services, they are actually relinquishing their cable television certificates, and instead of providing a traditional cable television package, they are combining their broadband service with YouTube television, right? We are trying to both serve the customer who wants a streaming package and also continue to serve the customer, many of whom are senior citizens. And you think about not to be general, I mean, I'm a senior citizen, so I like a traditional cable television package. I'm used to that. It's familiar to me. And I think there's a lot of, similarly situated people. So we're trying to do both. We're actually trying to continue to offer a very competitive cable television package while also making the streaming platforms more accessible and available to customers. And again, I think many of our competitors are abandoning that and moving away from it.
Yeah, thank you.
Can I just help because this wasn't a PC question, not commenting on the answer. Just
Or your mic.
I don't think your microphone is on, Attorney Cohen.
I'm a senior citizen as well, so technology is still new to me. Listen, I don't want to impact on any of the cross-examination, but the purpose of the questions, because they were OCC questions, was what are the companies charging for the retransmission consent fee, or also called the broadcaster fee? The difference should be the underlying reason for the differences is of interest, because the retransmission consent fees are with the same entities that own the local TV stations that both Charter and Cox carry in Connecticut. Therefore, if there is a difference, then what Attorney McCormick is asking for seems to make sense. Why? What is the components of what you put in the retransmission consent fee? And I hate to put it on Cox, but you might want to know that for balancing. That's all. I wanted you to explain why we were asking.
Okay, we seem to be going round and round here in terms of information that is requested and the ability or desire to supply that information. And if it is possible to drill down on the broadcast fees and explain the components, and I take your point. I mean, I just saw that was MLB and ESPN and NBC signed $800 million for baseball. I mean, I'm a huge baseball fan, so I get that. And I'm sure that's large part of the reason why those fees have gone up, simply because of this huge increase. But in the interest of wrapping this up, are you looking for the difference in the broadcast fees between the two and what's likely to happen in the future? Are they, I mean, there are certain questions I think that are unanswerable in terms of no one can forecast what the broadcast fees are going to be. Or, I mean, I think more to the point is our customers are still going to have the ability, if we're looking at that sort of thing, to buy a skinny package where they're not adding all this stuff. And we want to conclude this conversation, so.
Commissioner, I would put an emphasis on the last point, the the customer choice issues, the flexibility issues, as compared to the intricacies of pricing and cost allocation, given the nature of this industry. So some focus on that, the commitment, going forward to the customers along those lines.
Yeah. We sell our services on a national basis, and we've been able to develop a number of service offerings that I think are more responsive to individual customer needs. I wasn't suggesting before that scale in this particular context would result in lower costs or lower prices. But I think we've been very successful in coming up with unique ways to package and sell our services that are more responsive to consumer needs. Although rates of cable television providers haven't been regulated for a long time, this conversation may have been a different one at a time that we were able to break out the broadcast surcharge from the underlying price. At the present time, the broadcast surcharge is now consumed within the overall price that we offer to customers for the service. And so I don't know what the relevancy of the components of that are in the overall discussion about how we price our services. But beyond that, I think if the interest is ensuring that cable television customers have more choice and greater value and better opportunities as a result of the combining of these companies, I think the answer is clearly yes. And I hope that we've been able to demonstrate that to you because it is an important component of the public interest benefit that we intend to bring from this transaction.
Attorney McCormick, do you wish to take this further? Or are you satisfied with the responses so far?
Would I be able to request a 5-minute recess? Is that?
I certainly have
Yes, 5-minute recess is fine.
no objection. One thing I would note, I know that some of the witnesses have flights around the 5 o'clock time, so.
I'll bear that in mind, yes.
Yeah.
And I will be done well before the 5 o'clock.
Oh, well, they're gonna have to leave before 5.
That's good. Understood, but yes, yeah.
Thank you.
We will reconvene at 2:10.
With all due respect, Attorney McCormick, these aren't ratepayers.
Excuse me,
These are customers
customers.
that have choices. And we seem to be belaboring the point as far as this line of questioning. I don't mean to stop you, and I understand the passion and the interest in trying to protect people, but you can't protect people from themselves. And I'm just trying to understand where the fixation on packages that are common throughout the nation and across a number of similar companies, how it's going to affect Connecticut customers one way or another. They either will pay it or will not pay it, or have a reduced package. So I'm just trying to understand what you're protecting.
I can move on, Commissioner.
And do we still require a late file from Cox related to the surcharge?
Attorney McCormick, do you still request that?
Yes, I would still request that.
And can you say it again? To just,
Was it the reasoning behind the discontinuation of the surcharge?
Yes, reasoning behind the discontinuation.
and whether it was directly related to the FCC order or not?
Yes.
Yes. And then I think to Commissioner Karen's point, I know we do have people trying to, if you could proceed, if you have some really, really important questions that, or I'm not going to judge the relevance, you know best where you would like to apply your time, because we will want to allow some time for redirect, and there are some administrative matters we have to deal with before we adjourn. So,
Of course, Commissioner.
thank you.
Yes.
And just sorry, that was.
Can I just make one point if I may? I don't intend to answer a question for Cox. But the order that would have required you to disclose your all-in price was adopted by the FCC this year, not in 2021. So I don't know the reasons that Cox decided to discontinue it. But for clarification, the orders that would relate to creating an all-in price for video services that would include within that price the broadcast surcharge was something that was adopted by the FCC in 2020.
All right, I appreciate that. But if this is something to which Cox thinks it can respond and would be helpful to the Attorney General's office, I would appreciate a response.
Okay. Understood. And that's LFE 27?
Correct. Thank you.
One final question. Moving to a different topic. How long do the applicants anticipate that the combined company's headquarters will stay in Stamford, Connecticut?
As we stated in our application and in our responses, we expect to keep it in Connecticut. I can't make a promise or a commitment for a specific a period of time, but it's certainly our intention, as we've stated publicly, to do that. And as I again mentioned earlier, we spent significant amounts of money to build the almost 900,000 square feet of office space that we have in Stamford.
I have no further questions.
Thank you, Attorney McCormick. Do we have any redirect?
Thank you, Commissioner. We have no redirect. However, I do believe Mr. Murphy has the read-in that was assigned to us.
I'm not sure it ever got codified.
Really?
I don't know. I think Mr. Attorney Cohen, just let me promise to respond.
Okay.
I remember that.
Shall I go ahead with that?
I can have a second. I will allow Mr. Murphy to proceed.
Attorney Cohen? I believe you had asked if we had made we were discussing levered free cash flow. And you had asked if we had made any levered free cash flow forecasts. Okay. We provided in the proxy and in a subsequently filed 8K, a set of unlevered free cash flow forecasts to allow investors to make a valuation assessment of the benefits of the combination. So the short answer is no, we did not. But I would be happy to direct you to the unlevered free cash flow forecasts, which, depending upon what you were seeking, may give you an answer.
Now, on the record, if it's in the record.
Yeah. So the relevant forecast information is provided on page 75 and 76 of the proxy. We filed a subsequent 8K to assist investors with their assessment of the deal, some convenience calculations on July 21st of 2025. So those are obviously both available via the SEC or our investor relations website. We did provide a set of pro forma forecasts on an unlevered basis ranging from 2026 to 2031. What, if anything, would you like to know in addition to that?
That will be fine, the references. Thank you.
Very good.
We'll have our-
Great.
Nothing further.
Cox also does not have any redirect.
All right. Administrative matters, Attorney Cohen?
What's trick? Okay, we're on. Thank you. I'll learn. Briefing schedule. First of all, do we have a late filed hearing date at this point?
We are going to proceed with the original date for the late filed hearing schedule for 12/03. We do not expect to change that schedule because of a scheduling conflict with docket 250712. And we'll issue correspondence should there be a need to reschedule or cancel. But we are proceeding with that original 12/3 date if the LFE hearing is required. I'm getting raised eyebrows from Attorney Bogan.
No, I'm assuming that because I think you have the same conflict that I do. So
My understanding is we have more flexibility with that conflict than we do with this hearing.
some people think one Dave Bogan is one too many. So I can't split my.
You're gluttons for punishment. What can I say, Attorney Bogan?
It's fine. As long as you have a solution, that's.
Yes. And with,
I'm sorry, go ahead.
yep, go ahead.
No, we'll go back and talk about the briefing schedule. We'll see if we can accommodate the current briefing schedule or if we need a minor adjustment.
All right, we will await further information.
Thank you very much.
Are there any further matters to be addressed at this hearing today? Hearing none, I declare this evidentiary hearing concluded and adjourned. Thank you.